Dave, can you do roll call, please? Establish quorum.
Yes, sir. Darren Van Steenwyk.
Present.
Dave Tamayo.
Here.
Mike Duran.
Here.
Curtis Good.
Here.
So we have 4 members present, and quorum is established.
Excellent. Let's do the flag salute. Please join me.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. We would like to have public comment for items not on the agenda. Okay, hearing none, we will turn it over to the ALJ for our reinstatements.
Good morning. All right, our first petition hearing is going to be Ms. Charette. Is it Charette? Charette. Ms. Charette, if you would please come up to the table here. All right, I'm just going to just explain briefly how the hearing is going to proceed. We have a court reporter here, and his job is going to be to take down everything that's being said at the hearing. So once I say we are on the record, I'm going to announce the petition. I will have both you and Mr. Young announce yourselves for the record, and then I will go through how the hearing will proceed this morning. And then if you have any questions, you can ask me at that time, all right? It'll also be important that you have that microphone on so that everybody can hear you as well.
It's green.
All right, good. All right, then, we are on the record. Good morning. We are on the record. It's April 17th, 2019, in the matter of the petition for reinstatement of revoked license filed by Dawn Marie Charette. This matter is being heard before the Structural Pest Control Board, Department of Consumer Affairs, State of California. This is Office of Administrative Hearings, case number 2019-030-595. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings, presiding over this matter this morning with the board present. If the board members could please identify themselves for the record, starting to my left.
Curtis Good. Darren Van Steenwyk.
Dave Tamayo.
Mike Duran.
Right, there is a quorum present. Please, Mr. Young, if you would please state your appearance for the record.
Christopher Young from the California Attorney General's Office on behalf of the Attorney General.
And Ms. Charette.
Dawn Charette.
All right, and Ms. Charette, you're representing yourself this morning, is that correct?
Yes, that is correct.
And did you understand that you could have had counsel represent you at your own expense?
Yes, I understand that.
And you're choosing to proceed on your own behalf?
That is correct.
All right. As I mentioned before we went on the record, we have a court reporter here. His job is to make sure he takes down everything that's being said. So it's very important that you keep your voice up and that everyone takes turns talking, because he can't take down 2 people talking at the same time. The way the petition is going to proceed this morning is that the Attorney General, Mr. Young, will present the petition package that the board has before it. He will identify the documents in the petition package and then give the board members a brief overview of the history of your license, including any discipline and any documents as well in the petition package. After Mr. Young presents the petition package and a historical overview before the board, Ms. Charette, you'll be able to then testify on your own behalf. I will swear you in, and you can provide the board members any information that you want them to consider for purposes of issuing their decision. So the board members have the benefit of seeing all the documents in your petition package, so you don't need to repeat anything that is in the package, but you should provide information on rehabilitation that you've undertaken since the discipline of your license. Did you bring any documents with you this morning other than what's in the petition package?
I did bring a document that from the Department of Agriculture, San Diego, where my office was inspected, and we passed with flying colors.
All right. So did you bring extra copies of that
I
document?
did not.
All right. Is that something that you've provided to Mr. Young?
It is not.
All right. So what I will have you do is, when it's your turn to testify, you can provide information about that document. I will have you give it to Mr. Young so he can take a look at it. If it's something you would like the board to consider, then I will need to mark it as an exhibit, and then I will allow the board members to take a look at it. We can provide, make arrangements to provide a copy to Mr. Young as well. Other than yourself, do you have any witnesses who will be testifying this morning?
I do not.
All right. After you have finished testifying, I will allow Mr. Young to question you as well. And then after Mr. Young is done questioning you, then the board members will also have an opportunity to question you. And then because you have the burden of proof in this case, I will give you the last word. So if there's anything else that you would like to, any other additional testimony you would like to give, I will allow you to do that as well. At the end of the hearing, you both may give brief closing remarks if you wish. You don't have to, that's up to you, but you will be allowed to do that as well. All right, during the proceeding, I cannot give any legal advice, but if anyone has any questions about the procedures, please let me know, and if I can answer the question, I will. All right, any questions before we get started?
No, Your Honor.
No, Your Honor.
All right, then, Mr. Young.
At this time, I will present the petition packet. I have a copy for petitioner. Here you are. I've already provided a copy to the court. First, to mark as Exhibit 1 is the petition for reinstatement and related documents, which I will describe briefly. First is a March 7th, 2019 letter from the board confirming the hearing date and requesting confirmation. Second in the packet is petitioner's March 13th, 2019 confirmation. Next in the packet is the January 8th, 2019 letter from the board to the petitioner regarding the guidelines for petitions for reinstatement and a confirmation from petitioner of receipt of the guideline. Next is the petition itself, dated January 4th, 2019, received by the board on January 7th, 2019. Next in the packet is the petition for reinstatement of revoked license declaration, signed and dated January 4th, 2019, by petitioner Charette. Next in the packet is a request for live scan service for petitioner Charette, completed January 25th, 2019. Next in the packet is rehabilitation evidence submitted by petitioner Charette in 5 separate exhibits. Exhibit A, selected pages from Judge Matsuski's proposed decision, pages 2, 18, 19, 20, and 80. Exhibit B are pre-operator certificates dated December 2018. Exhibit C consists of continuing education certificates from various dates in March 2017 and April, May, June, and November 2018. Exhibit D comprises compliance inspection reports. And Exhibit E comprises a client testimonial dated January 17th, 2017. Next in the petition packet is a copy of the decision and order in petitioner's third petition for reinstatement, effective January 3rd, 2018. Next in the petition packet is a copy of the decision and order in petitioner's second petition for reinstatement, effective June 24th, 2016. And next in the packet is a copy of the decision and order in petitioner's first petition for reinstatement, effective January 11th, 2015. There are a number of appeal documents, related to this petition, which I will now also present, would you like these separately marked as different exhibits, or?
No, since
Okay.
it's all part of the petition package.
Okay. First, as an additional relevant document, is the Notice of Entry of Judgment denying a petition for writ of mandate. That's in case number 37-2013-000-52112, dated March 17th, 2014. Next is a judgment denying petition for writ of mandate, the statement of decision in the same case number, dated March 12th, 2014. Next is the verified petition for writ of mandate filed by Petitioner Charette in the same case number, dated June 7th, 2013. Next is a letter and decision after remand to the board, ordered May 13th, 2013, and effective June 12th, 2013. Next is a statement of decision by Judge Curiel in case number 37-2001-000-91163, dated September 30th, 2012, regarding Petitioner Charette's first writ of mandate. Next is a stay of decision in that same case number, dated January 25th, 2012. Next is the underlying verified petition for writ of mandate in that same case number, dated January 23rd, 2012. Next is the order of the board modifying the board decision, effective January 26th, 2012. Next is an order of non-adoption of the proposed decision by the Structural Pest Control Board, dated July 8th, 2011. Next is a proposed decision of Administrative Law Judge Matsuski, dated April 4th, 2011. That's 95 pages. Next is the underlying second amended accusation, number 2006-57, dated January 3rd, 2011. And finally, in the packet are certified license histories for the following licenses. Operator's license number OPR 9119. Branches 1 and 3, issued to Petitioner Charette. Field Representative's license number FR 21851 for Branch 3, issued to Petitioner. Next is a Field Representative's license number FR 12741 for Branch 1, issued to Petitioner. And finally is a company registration certificate for AMBD Incorporated, doing business as DNS Termite Control, number PR 1164.
All right, Ms. Charette, have you reviewed the documents in the petition package?
Yes, I have.
Right. I didn't explain this to you before, but you have the right to object to any of the documents that have been presented in the petition package. You must have a legal basis to object to a document, but if you have an objection and you don't know what the legal basis is, just please tell me. I'll get more information from you, and then I'll make a ruling on whether or not the document will be admitted into evidence. So with that explanation, do you have any objection to any of the documents in the petition package?
I do not.
Right. Exhibit 1, the petition package is admitted.
Next, I'd like to present the background facts for this petition and these licenses. Petitioner Don Charette, who is here today, was issued Field Representative License Number FR 12741 in Branch 1 on or about January 18, 1985. Approximately 8 years later, on April 16, 1993, petitioner was issued Operator's License Number OPR 9119, also in Branch 1. On or about May 1st, 1993, petitioner was issued Field Representative License Number 21851 in Branch 3. On or about May 18th, 1998, petitioner's operator's license was upgraded to include both branches 1 and 3, and Field Representative License Number 21851 was canceled. In March 2000, petitioner became the qualifying manager, the QM, for DNS Termite. In 2004, petitioner began serving as the president as well as the QM. In or about March 2006, an accusation was filed alleging a number of violations relating to a fumigation of a 30-unit condo building in San Diego in March 2005. The accusation was amended twice, resulting in the filing of a second amended accusation on or about January 3rd, 2011. That's second amended accusation number 2006-57. A hearing was held, resulting in a proposed decision that was non-adopted by the board. The board decision modified the proposed decision, resulting in the outright revocation of petitioner's operator's license, number OPR 9119, and a 150-day suspension of company registration certificate number PR 1164, followed by a 3-year probationary term for the company registration certificate. Petitioner then appealed the board's decision, which resulted in an order upholding the decision to revoke petitioner's operator's license, effective June 12, 2013. The appeals of the board's decision became effective on March 17, 2014. Petitioner now brings her fourth petition for reinstatement of operator's license number OPR 9119. The third petition was heard and denied effective January 3rd, 2018. The second petition for reinstatement denial was effective June 24th, 2016. And the first petition for reinstatement was denied effective January 11th, 2015. California Government Code Section 11522 requires a minimum of a 1-year lapse before considering a petition for reinstatement of a revoked license following a prior denial of a petition for reinstatement. Petitioner became eligible to file a new petition for reinstatement on January 4th, 2019, the date she filed this petition, so it is properly before the board.
All right, thank you. All right, Ms. Charette, it's now your opportunity to present your case. The first thing I'm going to have you do is please stand, and I'm going to swear you in. Please raise your right hand. Do you solemnly swear or affirm, under penalty of perjury, that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I will.
Please have a seat. And please state and spell your name for the record.
My name is Dawn Marie Charette. Dawn is D-A-W-N. Marie is M-A-R-I-E. Last name Charette, C-H-A-R-R-E-T-T-E.
All right, Ms. Charette. So the other thing I'm going to have you do is, since you did bring a document with you, I'm going to have you please show it to Mr. Young, and then I'm going to mark it as an exhibit so that the board members have the benefit of also taking a look at it. If you want to provide testimony about it, you will be able to do so. You would please hand me the document. All right. And so I'm marking it as Exhibit A, a pest control business headquarters inspection report.
Your Honor,
Yes.
would you like me to make copies of that?
If you would, that would be, yes, thank you. Thank you so much. All right, then, you may begin.
Good morning, Your Honor, members of the board. I come before you once again, not represented, but on my own behalf, and I have brought additional evidence again this year in regards to the requirements of rehabilitation, not only in the community, but within our industry. I have effectively passed the pre-operator exams, even in branch 2, which I was never licensed in. I got high scores on them. I got 80s plus, so I'm very happy with that. I did continue to go to several meetings where certificates were not issued. I do not have proof of them, but I did go. I did get proof when I was able to. This time I did obtain certificates. So most of the time they were not wanting to issue them to me because I do not maintain or hold a license. But after speaking with the people issuing the certificates, I finally got them to agree that, yes, I did attend. I passed the quiz at the end. Therefore, I should be able to be issued a certificate. So those are presented here. I have over this last several years had headquarter inspections, have passed them without any issuance of citations or anything. I keep my records clean. We're good with a safety training as well as training within the industry. I've recently started to attend the Department of Agriculture's fumigation committee meetings. I find them very informative, and they even get information from me because I'm actively running a business that conducts fumigations, and I'm there with other people in my community performing the same jobs as I do, but they carry a license and I don't. We have gone through hazardous materials inspections, have passed that. I am the person that maintains and makes sure that my company and its employees have the proper materials and everything to pass these inspections from our government's agencies. And then last of all, and I have submitted these in several copies, is on December 12th of 2017, my crews performed a fumigation in La Mesa. At that time, there was a distraught teenage boy there. The family was going through a divorce, and he just kept wanting to go back inside the house. The parents were not around. We went above and beyond to make sure he was not within harm of being within that structure. We vacated him. He went to a neighbor's house, but I kept sending people back to the property to assure that he did not re-enter that structure. I was on the phone with the police department for well over an hour trying to convince them that no crime had been committed, but we were in fear of something happening. And then later that month, I received a letter from his father thanking me for going above and beyond to save and make sure his child was safe. Then I have all my records of inspections from the Department of Agriculture showing that we are continuing to maintain the law, the safety, the everything. We did encounter a couple violations, actually just one. And that employee, I went in front of the Department of Agriculture. That employee is no longer with me. He had on other occasions had infractions. He was written up for them, and it got to the point where our company does not need this type of an employee, and therefore I released him from his position. I feel that I've done a good job of complying with requirements, and again, I'm asking that my license be reinstated.
All right. As I mentioned before, I'm going to allow Mr. Young to ask you some questions.
Yes.
Just like the documents I explained to you that you could object to any of the documents, you also may object to any question that Mr. Young asks of you. Again, you must have a legal basis for not answering a question or making an objection. But if you object to a question, just please tell me that you have an objection. I will get more information from you, and then I will make a decision and ruling as to whether or not you have to answer the question. All right?
Understood.
And the same process will be the same when the board members ask you questions as well. All right?
Understood.
Mr. Young.
Good morning, Ms. Schratt.
Good morning.
One of the primary functions of this hearing is to assess rehabilitation from conduct and behavior which the board found occurred in relation to the March 2005 fumigation of the 30-unit condo complex. So the board will assess honesty, integrity, character, and other aspects which are related to the duties and functions of an operator in branches 1 and 3. First, as far as criminal charges, do you have any criminal charges the board is unaware of?
No.
Are there any criminal charges pending against you in this state or any other jurisdiction?
No.
What makes you a good candidate for reinstatement?
Several things. I'm a good person. I have good communication skills with my clients. They feel comfortable knowing that I have the time behind me as well as the knowledge of our industry. I do find that some of them are dissatisfied to the fact that I do not maintain or hold a license. But at this point, I feel that over the several years that I've been going through these procedures and everything else, I've proven that I'm a good citizen and that I'm not a detriment or a harm to our community or our consumer.
And why do you want your operator's license reinstated?
I want it reinstated due to business purposes as well as pride. I do take pride in the fact that I have been not only active in our industry, but I'm able to do the duties of a licensee in any capacity, be it a branch 3 or branch 1. And at this time in my life, I think it's time to put this whole proceedings behind me and the board themselves and move forward.
Okay. As part of the petition packet, there's a Superior Court decision dated March 12th, 2014, judgment denying your petition for writ of mandate. It stated that, quote, your operator's license was suspended for knowingly violating the fumigation laws. As the qualifying manager present at the subject fumigation, she gave the order to remove food and medicine after the fumigation and did so to save time and money and had done so before. The time saved is time that may have resulted in Ms. Williams' life being saved, unquote. How do you respond to this factual finding?
Okay. I did make a poor decision to go ahead and move forward to fumigate the food as the fact of it was very time consuming. My intention was to have the food removed afterwards, but our timeline needed exposure for fumigant so we could get these 30 families back into their units the day of certification. And at that time, we were moving through to remove the food items. I do not believe Ms. Williams was in the structure during the fumigation, nor does the ALJ that heard our 19-day trial. I did without question, I did, and I admit, I fumigated food, and I'm not supposed to.
Okay. The decision goes on to state that you, quote, also failed to maintain the fumigation log accurately. How do you respond to this factual finding?
The fact is I did not maintain the log at all. My fumigator did. I did not have any involvement with the fumigation log itself, but it is my position to assure that it is maintained in a proper fashion, and I failed to look at the fumigation log prior to anything being submitted.
Okay. Now, you referred earlier to the proposed decision from Judge Matuski. However, the board's decision found that Ms. Williams was inside the building when the fumigation occurred, and the subsequent order on the writ of mandate found, quote, your company failed or negligently failed to clear the building. How do you respond to this factual finding?
I don't believe the Structural Pest Control Board's investigator was thorough. There were no charges brought against myself or my company from the San Diego Police Department or any government agency in San Diego. And I feel like I don't think they had the facts. They didn't go through the 19-day trial. Nobody from the Structural Pest Control Board, actual board in itself, was present during the 19-day trial.
What connection, if any, do you see between the failure to remove food and medicine before the fumigation and Ms. Williams' death?
I don't think that there's any connection at all.
So then, do you disagree with the Superior Court's finding that lessening the preparation time contributed to the death of Ms. Williams?
I disagree with that statement, yes.
And I believe your testimony at the hearing was that it would have taken 4 hours or so to complete the removal of food and medicines prior to the fumigation. Is that right?
Additional to the 2 or 3 hours we were already there, yes.
Okay. And in taking the extra 4 hours of time to comply with the label laws of removing food and medicines before the fumigation, you don't believe that Ms. Williams could have been located and could have been removed from the building?
I do not, because she was not in the building.
Okay, and you do understand that the board and the subsequent appeals have found that she was in the building at the time the fumigation occurred?
I've never seen the proof or the evidence that they've considered to come to that conclusion.
Okay. That same Superior Court judgment stated that Petitioner Don Charette was, quote, the one who fostered a corporate ethic of cutting corners to save time and money in a business in which safety and protection of human life must be paramount concerns, unquote. How do you respond to that statement?
I don't think I was cutting corners. I was, from where I stood at that point in time, it was a matter of I wanted to get these 30 families back in their homes and do what I was paid to do. It didn't save me any money by doing that. It did, however, get these people on their right timelines. You're talking 30 families with hotel rooms, animals on it that are being boarded, and things of that nature that it's not cost effective for them to be put through a prolonged process of fumigation.
Okay. And subsequent to the March 2005 fumigation subject to the accusation, how has DNS changed policies regarding safety and protection of human life?
We no longer allow food to be fumigated. We've even had issues where clients get extremely upset because they don't bag their food right. We throw it away. So, and it's in all my paperwork that states that if you don't comply with the way to prepare for fumigation, this are going to be the consequences of your belongings. So we no longer fumigate food. I have not only my head licensee, but a second person that makes sure we have all secondary locks and signs on the structure. And I make sure that my employees are trained more effectively than they were in the past. So we've changed a lot of policies, and when it comes down to it, we're very careful in regards to human safety and protection. And it shows, there's proof right here from a letter from a homeowner and his own son, and the circumstances that led to us moving forward and making sure that the consumer was taken care of.
How do you respond to the finding that the board found that you were negligent in this matter?
I've never disagreed that I was negligent on not removing the food. I am responsible for my employees. I understand that. Was I negligent at that time in regards to those items? Yes, I was. But I was not negligent in regards to the demise of Ms. Williams.
In the board's decision denying your third petition for reinstatement, the last one, the board stated that, quote, you denied that you were responsible for that death, stating that you knew for a fact the decedent was not in her unit or the complex when they were fumigated, unquote. And so you still maintain to this day that Ms. Williams was not in the structure during the fumigation?
Yes, sir, I do.
How do you explain to the board that was concerned that you were not taking responsibility for the death of Ms. Williams?
I will not lie. I claim that I did something wrong, which I did do. I will not come in here to get my license back by coming in and saying, I'm responsible for the death of Linda Williams. I am not. She was not in this structure at time of fumigation. I've got police reports, I've got an ALJ's report, and all kinds of investigations that prove otherwise. Therefore, I will not come in here and lie and say I was responsible for that, and that if I had done things differently, that she may have not died. I was asked last time I was here, is there any way that I'm trying not to see it the other way? I have analyzed this for the last 15 years and agonized over that. Could she have been in there? Evidence shows otherwise. I've got handprints. I've got shoes on top of extension cords that we ran through there. My fumigator didn't pick up her shoes and put them on top of the cord. And these are photographs taken by the police department before we could even enter the structure.
Okay. And on the last petition for reinstatement, the board was concerned that DNS had a pattern of placing its economic interests over the safety of the public, based on your admission that food and medicines were not bagged before the March 7th, 2005 fumigation. How do you respond to that concern?
I've never looked at it as an economic advantage to not remove food or anything of that nature, because it was our policy, no longer is, to, if there was food there, we'd bag it if it was a small amount, or we would remove it. And now it's completely different. And I've never seen it as economic. It's not a cost enhancement to us to not do that.
Earlier you explained some of the courses you've been taking. Is there anything else that you haven't already discussed that you're doing to remain current in the field of pest control?
I still effectively run DNS termite, and I make sure that myself as well as my employees are educated in the industry on the new techniques to eradicate or control insects.
And if the board were to reinstate your license, would you be prepared to complete continuing education as a condition of reinstatement?
Yes.
If the board were to require you to retake the exam for the operator's license as a condition of reinstating your license, would you be willing to retake the exam?
Yes.
If the board were to require a term of probation as a condition of reinstating your license, would you be willing to comply with probation?
Yes.
Okay, at this time, I have no further questions.
So council, here are copies of Exhibit A, if you would like to take a look at them, and if you could please provide a copy to Ms. Charette. And in looking at that document, do you have any objection to Exhibit A?
No objection.
Exhibit A is admitted. All right, now I'm going to open up questions to our board members, starting to my left. And if you would please just identify yourself for the record.
Yes, Curtis Gooden. Good morning, Ms. Charette.
Good morning.
Part of your discipline of your original revocation of your license was that's imposed that you are prohibited from serving as an officer, director, associate, partner, qualifying manager, or responsible managing employee for a registered company. Do you feel you're in violation of that order?
I don't recall reading it that way or seeing anything to that effect. I was not ordered to disassociate myself from the industry or the company.
I just read the order right there. And you just effectively said a minute ago, I effectively run DNS.
I help run it. My operator runs it, and I help. You can't run a company all by yourself.
No, I totally understand. I'm worried about this original order and discipline.
I don't actually run it by myself. I help run it. I'm more of an assistant and more an administrator than I am a person that makes the actual decision on what should be done for the company on a daily basis.
Okay, thank you. I have no further questions.
To my right.
No, I don't have any questions.
Good morning, Mrs. Chairman.
Good morning.
Could you just tell the board a little bit about the company that you run? It's family-owned. I know you've been in business for a long, long time, serving the San Diego area. And after you discuss to us or give us a little insight on, I believe it's your father that was an operator there for a long time.
That is correct.
Yeah, could you tell us a little bit more in depth?
My mother and father started this business out of their home. When I was 5 years old, I was paid to remove files from folders so they could be reused. I learned how to file folders and cards and all sorts of things. It then got to a point where my father could not handle it alone. He hired an employee. The company has started to grow and blossom since then. I took over the company almost 35 years ago. And when I took over, we were at 8 employees. Because of economics as well as drive, I got our company up to 54 employees, still never losing that connection with my employees. I honestly feel like my employees are my children. I take care of them. They take care of the company. We all work as a well-greased wheel. My employees, we try to take care of each other. We're more of a family than anything. I have employees that have been with the company for over 20 years, which is almost unheard of unless they're related in our industry. And I feel very prideful of that our company is put together well enough to do that. We effectively maintain a profit-sharing program because we want to make sure that in this harsh industry on your body, there's something for the employee at the end of the road. And we opened up a profit sharing program thinking a lot of people don't really think about their future and how they're going to deal with it. But my father and I decided, you know what? Yes, we need to make sure there's something for them rather than just their Social Security. Right now, we maintain 34 to 35 employees. We run the termite repairs, the pest control, the fumigation, and we're there for our community. And there's many a times, and not only I, but my father and everybody else has trained new staff members. Somebody calls in with a problem, don't think you need to send somebody out to make a buck. We try to get information from them over the phone and guide them in the right direction. For instance, bees, they have what they call a resting swarm. We'll come out, we'll look at it, and we'll go, it's a resting swarm. There's no charge for that. Whereas a lot of my industry people will say, yeah, I'm going to come out there, I'm going to eradicate it, and I'm going to charge you $200 for it. That is not our goal. Our goal is to make money, don't get me wrong. But we're not out there to gouge clients. If they have termites, we let them know. And we also let them know that you don't have to fumigate, which is more costly than a localized treatment. We give them options. There's other ways to control things. And in all, I think we're a really good company. Other companies' employees want to come work for us. We're well established. We just celebrated our 50th year in business. So I'm proud of it, and that's, as a whole, DNS, it's family.
Thank you, and congratulations on your 50th year of being in business. Question, how old is your father? And I'm assuming that if you obtain your license, or we reinstate your license, it's essential for the livelihood of the business to continue?
Yes, it is. My father right now is 83 years old. It's very harsh on him to comply and come into the office once a week, but he does it because this is what we need to do. And he spends a day with me and Mike Saunders and Randy Kroc going over, okay, this is what we're going to do this week, this is what we're going to do the beginning of next week, depending on his schedule. And he, frankly, is tired. He's 83. He did fumigations till he was 60. His body is tired, and he would like to retire.
I thank you for that answer. One more question, my last question. There's been a lot of controversy on this because we dealt it since the original starting point. Question is this. Being qualifying manager, I believe you were at the time, do you take full responsibility for everything that happened, or has happened with your company at that time?
Yes.
So, there's not moving the dollar over this, putting on a responsibility to anybody else. You assume full responsibility of everything that...
I do.
Thank you very much.
All right, any questions from board members?
Hello, Ms. Charette. Following up on what Board Member Good was asking about, what steps do you take to specifically ensure that your duties and your actions at the company don't bleed over into areas where a licensee is supposed to do that work? How do you maintain that? Because it sounds like you're very, very active in the running of the company.
I am administratively, and I have a lot more skills at doing research on things, and I bring it to the table for decisions to be made, not by me, but by others. I take in phone calls, what we call trouble calls, where people have complaints. I never go out to a job site without my licensee with me so that they can render the opinion. I do not go in and say, yeah, that's fungus and we'll take care of it. That is up to my licensee. The negotiations between the consumer and myself are more of the financial end of it, the shuffling of paperwork, things of that nature. I don't perform fumigations. The only time I go to a fumigation site is to deliver Gatorade or pizza. I'm very careful that I do not perform any licensee duties.
If there are issues that, say, staff out in the field need a decision made about that have to do with that should properly be handled by that decision referred to a licensee. Are you ever involved in that? Do the field staff see you as a decision maker as far as that type of?
I think I'm more of the mediator, because if they have a problem, I'm the first one they call, no doubt. But then I tell them I've got to call you back, or go ahead, just turn around, call Dave, call Mike, or call Randy. These are my branch licensees. But I basically, yes, I hear about what's going on everywhere. I do give my opinion, but I don't make the decision.
Why is it necessary for you to be a mediator when the actual decision needs to be made by a licensee?
Because most of the time I'm readily available. And a lot of decisions are based on financial things. They will come to me for that. Where there's damages or anything like that, they come to me. But when it comes to licensing duties, sometimes they'll come to me because Dave won't answer their phone, Mike won't answer his, Randy won't answer his. So then it's brought to my table, and then it's put out there again.
Could you give an example of, you just mentioned something like a financial issue. Could you give an example of the type of issue that would come to you that you feel that you can make that decision versus the licensee?
Yes. For instance, broken windows, it costs the company to replace that window. Therefore, they come to me asking, how do I deal with this? I put them in the right contact with the glass company that we have a relationship with. Just recently, a broken bird bath. My guys knocked it over with their tarps. They actually turned around and called Dave, and Dave said, I have no idea what it's going to cost, called on. So that's the factors of my involvement with the crews out there. I had a guy fall through a ceiling, a newer employee, and it costs money to fix the ceiling. So I am the one they reach out to because it's going to cost money.
Okay. Thank you.
All right, any additional questions from our board members? No? All right, Mr. Young, any follow-up with Ms. Charette?
No follow-up.
All right, then. You now both may give closing remarks. As I mentioned, Ms. Charette, because you have the burden of proving that you should have your license reinstated, I will allow you to give closing remarks first. Mr. Young will then be able to give closing remarks, and then I will give you any last word. All right?
Yes.
You may begin.
Once again, I come before you. I would appreciate my license being reinstated. I feel that I could be a better service to the community if I have a license, so there's not a delay when it comes to making decisions, rendering an opinion, or anything of that nature. Sometimes my clients feel very uncomfortable that I don't maintain and hold a license. And they asked me why. And it brings this all up again. I deal with this on a daily basis. I don't go home and forget this happened. I don't go home and forget any of it. I take it with me. I just think I'd be more of a service to my consumer, my clients, if I maintained a license.
All right, thank you. Mr. Young?
Based on today's testimony, it's apparent that petitioner still does not accept the board's findings that Ms. Williams was in the structure at the time of the fumigation. That was determined by the evidence before the board obtained through this 19-day trial. That evidence was reviewed independently by two separate Superior Court judges on appeal. They also found that Ms. Williams was in the structure. A failure to accept the factual findings of this matter and to put forth some alternative facts simply shows that petitioner still has failed to fully grasp the board's concern that that she denied she was responsible for the death, and stating that she knew. Again, she's stating that she knows that the decedent was not in the structure. Based on this failure to take responsibility, there's certainly a question as to whether this petition of reinstatement should be granted.
Ms. Charette, any final remarks?
Yes. I sat through a 19-day trial, and I have Judge Medowski's findings, everything. I cannot understand how the board found any clear and concise evidence that Mrs. Williams was in that fumigation, where she states clear and convincing evidence did not establish that the woman was in the complex when the fumigation began. In fact, strongly suggests that she entered the unit only a short time before she was discovered. I have never been privy to the information that was provided to the board other than the hearing from the ALJ. So I don't know where the decision came from or how the board can state that they have evidence. I've never seen it.
All right, anything further?
Nothing further, Your Honor.
All right, is the matter submitted for the board's consideration? Matter
Yes.
submitted? Matter submitted?
Submitted.
Matter submitted. The board will go into closed session after the next petition hearing, so you will not be receiving a decision today. You will be receiving a decision sometime in the future. All right, off the record. I have a form that gives information on how to obtain a transcript of the hearing. If you wish to get a transcript, you don't have to, but you have to take the form with you. And then once you have that form, you're free to go.
You just want to move straight into the next one?
Whatever you want.
Works for me.
Yeah.
You guys okay just moving straight into the next one?
All right, Mr. Delora, is that correct?
Yes, Delora.
You can have a seat. All right, is everyone ready? Yes,
No,
we're gonna.
he's not.
Oh.
He's shaking his head.
Oh. That's fine. We're gonna talk about a few things before we go on the record, so you're fine. So, Mr. Delora, as you know, you've been sitting in the petition hearing before you. In just a moment here, we'll be going on the record. I'll announce the case. I'll have you and Mr. Young both announce yourselves for the record, and then I will just briefly explain how the hearing is going to proceed. If you have any questions at that time, then you can ask me, all right?
Okay.
All right, everyone ready? Yes?
Yes.
All right, on the record. Good morning, we are on the record. It is April 17th, 2019, in the matter of the petition for reinstatement of revoked license filed by Jesus de Laura. This matter is being heard before the Structural Pest Control Board, Department of Consumer Affairs, State of California. This is Office of Administrative Hearings number 2019-030-876. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings, presiding over this matter this morning. And there is a quorum of the board present this morning. Counsel, with the Attorney General's office, if you would please state your appearance for the record.
Christopher Young, Deputy Attorney General.
And Mr.
Jesus de Laura.
Mr. Delara. All right, before we went on the record, I briefly just stated that I would go over how the petition hearing is going to proceed this morning. As you know, you were sitting in the previous petition hearing, so you know some of the ground rules. It's important that you make sure that you speak up so that we can hear you and so that our court reporter can hear you as well. The matter this morning is a petition that you filed for reinstatement of your license, correct?
Yes, that is correct.
And you understand that you have the burden of proving that you should have your license reinstated?
Proof as in what?
So you have the burden of demonstrating to the board that your license should be reinstated.
Yes.
So the way the hearing is going to proceed this morning is Mr. Young is going to identify the petition documents.
Okay.
He will also give the board members a brief overview of the history of your license and the discipline that was imposed on your license. After he does that, you will have an opportunity to present your case. You may testify on your own behalf. Did you bring any documents with you this morning other than what's included in the petition
No,
package?
just whatever was included.
All right. So with regards to any of the documents in the petition package, if you have any objection to those documents, please let me know.
I will.
And then I will make a decision about whether or not any of the documents should or should not be admitted into evidence. You will be allowed to provide the board information concerning all your rehabilitation efforts since your license was disciplined.
Yes.
And then after you've testified, I will allow Mr. Young to ask you any questions that he has. As you know from sitting in on the last petition, as I explained, you may object to any question that's asked of you. If you have an objection, please let me know, and then I will hear the reason for your objection. I'll make a ruling on whether or not you're required to answer the question. After Mr. Young questions you, then I will ask the board members if they have any questions. And then after they're done questioning you, I will allow you to provide any additional testimony. At the end of the petition hearing, I will allow you both to give closing remarks if you wish as well.
Thank you, Your Honor.
Any questions concerning the hearing? Okay. Also, you're representing yourself, is that correct?
Yes, I am representing myself, Your Honor.
And you understand that you could have had counsel represent you at your own expense?
Yes,
And you're choosing to proceed on your own behalf?
I am choosing to proceed on my own behalf.
All right, then, thank you. Mr. Young?
At this time, I would like to present Exhibit 1, the petition for reinstatement and related documents, consisting of, first, the March 7th, 2019 letter from the board confirming the hearing date today and requesting confirmation. Next, petitioner's March 20th, 2019 confirmation. Next, a January 4th, 2019 letter from the board to petitioner regarding guidelines for petitions and confirmation from petitioner of receipt of those guidelines. The petition for reinstatement itself, dated January 23rd, 2019, received by the board on February 25th, 2019. The petition for reinstatement of revoked license declaration, signed and dated January 23rd, 2019, by Petitioner DeLara. Next is a copy of accusation number 2017-72, just a few pages, pages 15 through 16 and 22 through 25. Next is a request for live scan service for petitioner, completed February 21st, 2019. And next is a rehabilitation document submitted by petitioner. It is a letter from Ryan Myers, manager of EcoShield Pest Control. It's neither dated nor signed. Next is a copy of a March 2nd, 2018 letter from the board to petitioner serving the default decision and order revoking petitioner's field representative license. And next is a copy of the default decision and order revoking petitioner's field representative's license number FR 44208, effective April 1st, 2018. Next in the petition for reinstatement packet is a copy of accusation number 2017-72, dated June 28th, 2017. That's 26 pages. Finally are the certified license histories for petitioner DeLara. The first is his field representative's license number FR 44208 for branches 2 and 3. And the certified license history for petitioner's applicator's license number RA 47670 for branches 2 and 3. And that completes the presentation of the petition packet.
Petition package has been marked as Exhibit 1. Mr. DeLora, have you reviewed the documents in the petition package?
Yes.
Any objection?
No, no objection.
Exhibit 1, the petition package is admitted.
And at this time, I would like to present some jurisdictional and background facts. Petitioner Jesus DeLara was issued applicator's license number RA 47670 in branches 2 and 3 on or about July 10th, 2007. On or about April 3rd, 2009, petitioner was issued field representative license number FR 44208 in branch 3, and his applicator's license was downgraded to only include branch 2. On or about July 11th, 2011, petitioner's field representative license was upgraded to include branches 2 and 3. On or about June 28th, 2017, accusation number 2017-72 was filed against field representative license number FR 44208. Petitioner did not respond to the accusation. Therefore, on or about April 1st, 2018, a default decision and order was entered resolving the accusation and revoking petitioner's field representative license. Government Code Section 11522 requires a minimum of a 1-year lapse before considering a petition for reinstatement of a revoked license following a final decision. It has been more than a year since the effective date of the revocation.
All right, Mr. Delore, it's now your opportunity to testify. Please stand and I will swear you in.
Yes, ma'am.
Please raise your right hand. Do you solemnly swear or affirm, under penalty of perjury, that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Please have a seat. And please state and spell your name.
First name Jesus, Jesus. Last name Delara, D as in David, E as in Edward, Lara.
All right, you may begin.
Well, Your Honor, at the time that all this incident happened, I was involved in a really bad car accident. I did not know all of this was happening, and at that point, to be honest with you, I didn't care if I didn't know if it was happening. My health was my main concern. I didn't think I was ever going to come back to pest control. I didn't think I was going to be able to function as a normal person at that point. I had really bad back, shoulder, wrist, neck injury while working. And like I said, to be honest with you, all of this didn't matter to me. Short time after, well, actually 2.5 years after, I was allowed to return to work with very small limitations. Pull, push, lift 25 pounds. And a good friend of mine, Mr. Ryan Myers, caught wind of this, and immediately he wanted me to work for him. Also, another good friend of mine, Jeremiah Goins, heard of the same thing. They both wanted me to work for them because of my work ethic. I've always been good standing, very loyal, law-abiding. I've never done, or I live by, it's immoral, illegal, or unsafe. I don't do it. And these people really like me for that. And they wanted me to work with them. I went to initially work with Jeremiah for Top Notch, and I noticed that my license had lapsed. Jeremiah did inform me that there was some things going on with my license. I went ahead and applied for my license. I then found out that there was a lot of violations that were thrown at me. And I found out that I was revoked at that time. Jeremiah no longer was able to keep me as an employee. He didn't have a position for me. It's a small company. He decided to let me go because obviously I don't have a license, and he wanted me to run general pest for him. Although Ryan Myers with EcoShield Pest Control said he would have a position for me, and I've been there ever since. Not doing anything pest control related per se, more equipment handling, repair suggestions for exclusion work, more so handling, follow-up calls with customers regarding damages done by technicians. Very nice incident where a technician didn't fall through, but stepped on a ceiling. It took several months and lots of time to attempt to fix. Again, standing on the sidelines with EcoShield, not doing anything really pest control related, is where I'm at now. Sitting in all the classes, anything with continuing education, I sit in. Obviously, I can't write my name down on anything because I don't have a license, but that's where I stand right now. I know this isn't really pest control related, but during this time, I also went through a divorce. I now have custody of all my kids, just 5. I am a true single dad, and I really would like to move forward with my life, and the best way for me to provide for my family would be to have my license reinstated and have the full ability to do what I do best, and that is pest control, and to serve our customers. Customer service is one of my key factors of what I do.
All right, thank you. Mr. Young?
Okay, one of the primary functions of this hearing is to assess rehabilitation from conduct that the board found occurred in relation to the allegations in the 2017 accusation. specifically that you had completed 10 WDO inspection reports that were non-compliant with regulations. So what have you done since 2017 regarding WDO inspection reports and ensuring that you can complete them according to regulation?
Our branch does not do termite. I have not done anything in regards with practicing termite control. I don't wish to focus at this point with anything to do with termite control. I want to focus more with general pest. I have read and understood what was wrong with the forms I filled out, and I've had several other friends explain to me exactly what was done wrong, and it was my fault. I didn't follow up on the proper forms there. I do admit that.
Okay. Let me go back. Just as far as criminal charges, do you have any criminal charges that the board is unaware of?
No.
And are there any criminal charges pending against you in this state or in any other jurisdiction?
No.
Mr. Delara, could you just describe what you've already told the board, but what makes you a good candidate for reinstatement?
Well, I haven't. Before then, I've practiced both termite, general pest, and pretty much it's a basic applicator duties. I've always followed all the rules. I don't believe I have any violations. I've been, field audited in numerous occasions. I've always passed every safety inspection, not just with the rules that we have to follow because of the state, but also with company policies. That I'm very honest. I'm very compliant. I show loyalty to who I work for and just general public. Great customer service. This is what I like to do. This is in other words my puppy. I love doing pest control, and that's all I got.
Okay. And so you mentioned earlier that you've been attending trainings and classes with EcoShield. Is that right?
I sit in all of their the classes they have available. I don't miss any of them. I don't have proof of any of that because I haven't written my name down or anything. But when we have Tuesday morning meetings, I try to be there every time, and especially if we're going to have a guest speaker with anything, rodent, safety. It doesn't matter. I'm there.
Okay. And you're working full-time at EcoShield now?
Well, I try. There's sometimes not enough for me to do, obviously, because they are a pest control business. I don't have the proper licensing for me to perform a lot of the duties that need to be done there. I'm more like an assistant. I sit on the sidelines pretty much the whole day. If anything comes up non-pest control related, that's where I am. If anybody needs help with a repair, I'm there. But lately, people have been focusing more, especially with the summer coming up, on just doing their general pest, and a lot of the extra stuff isn't really coming up. So I am legally, technically, full-time employee, but I'm not there the full 8 hours every day.
Okay. And in mitigation, you submitted the letter from Mr. Ryan Myers.
Yes.
When did you get that letter from him?
This is the first time I'm reading it, and it's very touching me. He gave it to me, and I put it in an envelope, and I sent it to you guys. I didn't want to read it at the time. I haven't finished reading it yet, but all of this is pretty much true and dead on with Mr. Myers.
Okay. So he gave it to you within the last year or 6 months? Or?
Just about, yes.
Okay. Is there anything else that you're doing to remain current in the field of pest control?
I do have, through Univar, an app where I go and do continuing education stuff. I try to print out things. I don't have internet access at all times, so I have on paper when I have downtime. I just dig my face on anything current or new and up and coming.
Okay. And if the board were to reinstate your license, would you be prepared to complete the required number of continuing education courses as a condition
Absolutely.
of reinstatement?
Absolutely. It's never been a problem before. I've always stayed current with all of my continued education hours. I've never had an issue with my license ever in my about 10-year run with pest control.
And I saw somewhere in my files that you would recently retaken the field representative's exam. Is that correct?
I did. I took it to try to work for Jeremiah. I didn't think it was going to be this big of a deal where I was going to be revoked, and I passed.
Okay.
No problem. Yeah.
And if the board were to require that you retake the exam, would you be prepared to do that?
Absolutely.
And if the board were to require a term of probation as a condition of reinstating your license, would you be willing to comply with probation?
Yes, that would be not an issue for me.
Okay, at this time, no further questions.
All right. Opening up questions to our board members, starting to my left.
Good morning, Mr. Delara.
Good morning, sir.
Maybe I just missed it. What test did you just recently take that you passed?
The branch 2.
Just branch 2.
Yes, sir.
So are you before us today to get that license? Because typically when you come before me, if I read your file correctly, you had originally a field rep branch 2, branch 3.
Yes.
Correct. So that's what we'd be looking at reinstating.
Oh, both. Oh, that's fine. I'll take both the tests. No problem.
If that were the case.
That were the case, yes.
Okay, I have maybe just one question. I don't go back. I don't miss or wish to go over your original case and what got you in trouble, but what have you done because there's a lot of unusual causes of actions that ultimately ended up losing your license. What have you really done to correct that?
Nothing. I'm staying away from termite
No,
as of now.
Okay, but you haven't gone back to study any of those reasons why? Have you really looked at those reports and those files and what got you in trouble?
I did look at them when they were presented to me, and there were things I should have looked at. I'm the keeper of my license. I should have double checked. I assumed all those forms that were given to me were the proper forms that I needed to fill out. When working with Terminex, they also provided forms, and I trusted that those forms were fine. But at the same time, I'm at fault there. I should have doubled up and checked up on all those forms and made sure they were the proper ones before I completed any inspections.
Okay, great. Thank you very much. I have no further questions.
Right to my right.
Thank you. I have just one question. I see nothing on your file here pertaining to the accident, the industrial accident you had. It was work-related?
Yes, sir. I am still finishing up that workman's comp case. Actually, this morning at 8 o'clock, my attorney's in court for me in Pomona. It's still not done. I'm still going through workman's comp. I am not 100% released yet.
Okay. So that injury happened and you just completely just didn't want to have anything to do with...
I did not at that time, to be honest with you. I was more concerned with my family, my well-being, my health. A really bad back injury. I couldn't even tie my own shoes. My son had to do loopholes for me around my belt. So pest control work, anything else in the world didn't matter to me at that point. I didn't even think pest control was going to be a thing for me anymore, or work, having an actual job. I thought I would maybe possibly be in permanent disability.
Thank you, Mr. Delara.
All right, any further questions for our board members?
So under the different causes for discipline, it doesn't seem to me that it's about submitting the wrong forms. It seems that there is either a lack of understanding or a lack of taking responsibility for filling out the forms correctly and doing the job correctly, which is what the license is supposed to be all about. What have you done to demonstrate that you've taken action to show us not that you know how to comply with the requirements of a license?
I have not. I have not had the opportunity to review the correct way of remedying what I did wrong. Like I said, I'm just getting my feet wet and getting back into pest control. I've only been working for Mr. Myers for about a year now, and really with nothing to do with termite control. So I'm still a little in the dark of what to do there, how to fix that, how to remedy that. And like I said before, I would like to stick more with general pests at this moment. I don't think I would be able to do any termite work regardless, because of the limitations I have to the physical limitations I have now. I don't think I would be able to climb or crawl very well in an attic to do a proper termite inspection anyhow.
What we're tasked with is not looking at so much what the original cause was, but what you've done to demonstrate that you've taken action to not do it that way again, regardless of whether it's branch 2 or branch 3.
I understand.
So with regards to branch 2, how can we be assured, since you didn't take responsibility in the past for fulfilling the responsibilities of your license, you haven't taken steps to make sure that you to show us that you know how to fulfill those obligations. How should we be assured that you would take that responsibility if you're granted a reinstatement of your branch 2?
I can pick up some study material. I could start learning both branches. Passing that test would probably grant you the proof that I've looked over and refreshed all my courses in both termite and pest. I believe so. If you would take that as an answer.
Thank you.
All right, any further questions from our board members? Mr. Young, any follow-up questions?
No follow-up.
All right. Then, with that, Mr. DeLaura, if you'd like to give closing remarks.
I have nothing further, Your Honor.
Mr. Young, any closing remarks?
No closing remarks.
All right, then. Mr. DeLaura, is the matter submitted for the board's consideration?
Yes.
Matter submitted, Mr. Young?
Submitted.
All right. Mr. DeLaura, as you know, the board will be going into closed session to make a decision. You will not be getting a decision today. You will get a decision sometime in the future. All right, the matter is submitted and the record is closed. We are off the record. Right, I have a form that gives information about how to obtain a transcript of the hearing, and once you get that form, you're free to go.
Thank you.
And then I let you announce closed session and take care. I'm done. It's all you now.
Just a second.
Okay.
So we're going to go into closed session right now. And then it shouldn't take any longer than hopefully 30 minutes to an hour or so for closed session. And then we will go back into open session after that. So we'll see the public in a little bit. Thanks. Going to go back into open session. Thank you everybody for joining us again. Those of you online, we appreciate you watching us. Okay, so after we reconvene, review and approval of minutes of the January 15 and 16 board meeting. Susan, did you want to comment on that or take it from here?
I don't have any corrections.
Okay. Does anybody else have any corrections or comments?
I already reviewed.
Okay. Okay. So we have one move. We have a move to approve.
Second.
Okay.
Second is
Mike.
Okay. Then we have a comment from the public. Okay. Hearing none. Any other comments? Okay. Susan, you want to take the roll call vote, please?
Jim. Curtis Good.
Yes.
Dave Tamayo.
Yes.
Darren Van Steenwyk.
Yes.
And Mike Durant.
Yes.
Okay. So moving on, discussion and possible action of the occupational analysis for applicators. This is something that our industry has been asking for because of it's directly tied to the applicators exam. So Susan, you wanted to walk us through the next steps as to what that will look like, please?
Sure. So in your board packages, you have a project plan for conducting a new occupational analysis for the applicator classification. It's pretty aggressive. I'm not sure that we can stick to this timeline, but I think it's probably pretty close. The only thing that I was looking for from you folks is possibly, I was thinking maybe possibly an October stakeholder meeting, maybe in conjunction with the board meeting for attendance purposes and participation.
And the stakeholder meeting, just for the sake of the public, would specifically, what would be the specific purpose of that stakeholder meeting?
To get input from your continuing education providers, from the industry, from all the folks.
Okay.
There was a lot of discussion about operators not being able to actively work in conjunction with Office of Professional Examination Services on a new occupational analysis. So everyone would be welcome to a stakeholder meeting.
Okay, so that would be an opportunity for operators, for field reps, for people that train
Yes.
applicators to have an input on the occupational analysis on the OA, which will then link to directly or be used as a reference for the test.
Yes.
Okay.
Yes.
Okay. I think that I really like the idea of that. I also like the idea of potentially having it in October, which combining with with our board meeting. Any discussion here from the board on that? Okay, discussion for the public. Now's a really good time for you guys to talk. Please step forward and identify yourself into the microphone.
Mr. President, members of the board, Chris Reardon, Pest Control Operators of California. We obviously concur with the decision of this board and the executive officer. We think it's a great idea to sit down and talk stakeholder group. As you know, we've been talking for some time about the examinations, and an opportunity for us to get everyone around a table, as you know, I think would be very fruitful. So very, very, very supportive.
Okay, and so October, is that a real time or is that a stretch for that stakeholder meeting?
No, I think that's full time.
Okay.
I think that's full time, and that would be in conjunction with October meeting. That would most likely be held here.
Okay.
So we would do that in conjunction with Office of Professional Examination Services, of course.
Fantastic. Okay. That sounds good.
Great. That'd be great.
Thank you. Do we need a motion on that? No? Okay. As far as kind of moving through the rest of the time frame, it sounds like June of 2020 is theoretically when the workshops would happen then to rewrite the applicators exam. Is that what I'm interpreting? Is that what I'm interpreting? And I'm now making up words. Interpreting from this?
Yes.
Okay.
The only thing I would probably be looking for is if we're going to do it in October.
Can you choose your microphone? Thank you.
Sorry. If we're going to do it in October in conjunction with the board meeting, then we're probably looking maybe like a 2-hour meeting. Would you want to do that maybe on the morning before the board meeting? If we have an afternoon board meeting for reinstatements, does that sound reasonable for everyone?
Yes, I think so. Now we'd have to be careful about how many board members show up, correct?
Correct.
Okay. Because other words, it becomes a board meeting.
Right.
But we can, I think that we could potentially work the details out for that either before, especially if it's a 2-day afternoon, morning, we could either do it the morning of or the afternoon. But,
Right.
But yeah, but I don't think that would be too much of a stretch.
Okay.
Okay. This is great. Thank you. Thank you for this. This is something that industry's been asking for. So we definitely appreciate that. Okay, so moving on. Any other comment from the public on this? This is one of the places that the board is very much responding to industry. So as a result of that, we are hoping to get as much participation and support in this process as possible. Please identify yourself and let us know what you think.
Todd Vadine, Terminix. I spoke on this issue last time, and I concur with your approach about having a stakeholder meeting, as well as Chris Reardon. Having just participated in a Branch 1 workshop in Southern California after lack of participation, because most of fumigation occurs in Southern California, I think we had a very successful meeting. So I think getting the stakeholders together to move this process forward would be a very good thing to do.
Excellent. Thank you. Thank you. Okay, so moving. So it sounds like we're good there. Moving on to AB 2138 and the potential and the implementation of that. This is something that again has major potential implications on our industry. Susan, did you want to fill us in on this one, please?
Sure. So AB 2138 got passed through the legislature last year. It became effective 1/1 of 19. It substantially changes how we can look at criminal histories and backgrounds and substantially related criteria for our licensing of individuals. So in your board packages, Dave has been working very closely with Sabina and legal. In your board packages is proposed regulation changes that will be necessary to move forward with the new guidelines established in 2138.
Okay. So this, essentially, we would need a motion to adopt this into regulation, correct?
Each of
the two separate sections.
There should be three.
three.
Three separate sections is what I said.
No, two sections in your changes to your forms.
Yeah.
And we would need that nice long reg motion that I like to read out, and so we can move forward with the regulatory package and give authority to your executive officer to complete the rulemaking file.
Okay. Before we go there, any discussion from the board on this? No? Okay, any discussion from public before we move forward with the motion? Okay. Can you please, would you mind telling us our motion that somebody's going to make and then somebody else is going to second?
Excellent. I move that we approve the proposed text for a 45-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes if there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
Okay.
So somebody may move that.
Dave got all that 100%? Yep. Okay. Can we get a motion for that, please?
I'll make that motion.
Okay, a second? Okay, discussion from the board? Okay, discussion from the public. Okay, so let's do a roll call vote, please.
Darren Van Steenbeck.
Yes.
Dave Tamayo.
Yes.
Curtis Good.
Yes.
And Mike Duran.
Yes.
Excellent. So we're moving forward with that. That means that we will be compliant with we will be compliant with AB 2138 once all of this goes through.
Yes, which we are required to be compliant with by July 1st, 2020.
Excellent. Do you think we're going to make that time frame? Excellent. Okay. EO report.
So in your board packages are licensing survey results and statistics, WDO statistics as well. If you have any questions or comments, I'll try to address those. And I have just a couple other things that I wanted to mention.
Okay. One of the comments that I would like to at least bring forward or mention is the passing rates for the applicators and the field reps are up from this year over last year. And as an industry, we appreciate that because it means that we're able to get employees into the field a little bit faster.
Okay.
Any other comments or anything before Susan talks about whatever she wanted to mention next?
Okay. I have just a staffing update that I wanted to bring to the board members' attention. We recently lost 2 staffing members in our enforcement complaint unit. Kevin Lau, who had been with us for several years, 6, got promoted to another agency, so he left just recently, April 5th, I want to say. And then Maria Perez, also in the complaint unit, she also left us. She was lucky enough to find a job that her commute is now 5 minutes, so I lost her.
Okay.
So, yes, good for her. We are moving one person in licensing and promoting that person, Rachel, into the complaint unit to take one of those positions. We've also already done interviews to replace the other position. That person, Holly, will be coming on May 1st. We've also recently did interviews again for our applicator desk. That's been vacant for some time. Our lead over licensing has been handling the lead position and that desk for about a year now. We recently did interviews again for that position. We were just having a lack of good candidates, but we have made a job offer, so we're waiting to get that paperwork approved and bring that person on. May not make it by May 1st, but it should be very soon. And then our specialists, our investigators in the field, we had 2 that retired last year. Robert and I conducted interviews in January. We finally got approval just 2 weeks ago, last week, to bring on a new specialist for Northern California. So Jeff Meringue is also targeted for May 1st. He should be starting on May 1st with us as well. The Southern California position, we have determined that we're not going to fill it at this time. We'll conduct interviews again in the near future. And then any comments or questions on those? Okay. And I just wanted to briefly mention something that Todd from Terminex mentioned. We did have our occupational analysis for the OPR Branch 1 and the FR Branch 1 workshop. That was held March 28th and 29th. Curtis, again, thank you for offering your location. I think that was very beneficial in getting participation, because it was being conducted in Irvine. Just for your sake and for the industry that's here, for them to know, we still struggled to get participation. We really struggled, even though it was in Southern California. I did some research. I was kind of curious. I mean, we do have just under 1,000 FRs that are licensed in Branch 1, and we have almost 500 operators that are licensed in Branch 1. But even the survey that was, the Survey Monkey that was sent out prior to the workshop, we only had 21 field reps that responded to that and 24 operators that responded. So a very, very small sampling. So just kind of want to get the word out there, because when we start having workshops to write new exams, we're going to have the same difficulty getting people in the room. So I'll be making phone calls and asking for help, just so you know. Okay? And that's all I have for the EO update, unless you have questions or...
Nope, I don't. I don't have any. Hopefully, PCOC can help continue to get people in the room. But if they just don't want to be there, then there's only so much we can do.
Right. And if they don't really want to be there and participate, you probably don't want them in the room. But we've got to have good candidates in those workshops.
Yeah. Any comments or questions on the EO report from the board?
Well, my only comment to that, Curtis, would be that for those field reps, particularly for the branch 1 work, that really just needs to be done in the wintertime. Even March, they start getting busy, so you might have a little better participation. I know you don't want to do it too much in December, but maybe early December. But January and February is the real critical times. It's just hard to bring those guys in and out of the field.
Right.
Everybody starts getting real busy.
Well, the first workshop was at the end of November, and we struggled getting people to that one, too.
Yeah, we fought hard.
Yeah, I know. But we pulled it off. We got enough people in the room, so.
Thank you. Any comments from the public on the EO report?
I just wanted to say, Chris Reardon again with PCLC. We'd be happy to work with you, Susan, on particularly locations. Mike just mentioned Orkin could offer locations in Riverside, and so we'll work actively. As you know, we were getting the word out, and we just got done our board meeting and got the word out. But we'll do whatever we can, and if we can find better locations or more opportunity, we'll do that.
Okay, and I really do appreciate that. I appreciate PCOC support. I know that Sarah is on a regular basis putting those workshops on your guys' website and trying to bring attention to the industry that we're having ongoing workshops, and not just, of course, Branch 1, but we're having ongoing workshops for the field reps and operators in Branch 2 and Branch 3, just to continually rewrite those exams and keep those questions current and valid.
Yep, I agree.
I don't know if it's feasible, but the quarterly meetings that PCOC has, they have a bunch of individuals together. I don't know if it's some way to coordinate it with PCOC in their meetings and just set up a side group. It would be an outstanding opportunity for both to work together. If that can be explored, because you have people are actively involved in the industry, and I think would be a very good resource for you.
Okay, we'll try and explore that. Typically the workshops, except for the occupational analysis, because it's a little different workshop, but typically they're done at Office of Professional Examination Services, where it's a secure environment. Cell phones aren't allowed even in that workshop room. They have the computers. Available to the participants, but we'll see what we can do and be creative.
Well, it'd just be a great opportunity, and I think they can find a secure room and everything you need. We found it in my office and worked out pretty well, but you have all the best minds in the industry and that are actively engaged in the business, and I think they would be your best candidates.
Okay.
Well, and even if we don't utilize something like what Curtis is saying for the Branch 1, we may be able to explore that idea for some of the RA work that we want to do as well.
Mm-hmm. Yeah,
absolutely. Excellent. Any other questions or comments on that? Fantastic. Moving on to the research proposal update. I'm sorry, did I cut you off, Susan? Do you have anything more to talk about from the EO report?
No, I'm good.
Are you whispering?
Oh, and I should turn that off if I were whispering, huh?
Okay, so the update on the research proposals. We have asked for a report a quarterly report from the researchers by the end of this month. So theoretically, that should be, we should have some of that, at least this one, in the next board packet, I would assume.
Right, yes.
Okay.
So what's in your board packages is just what you'll see in every upcoming board meeting. It just gives you some information on kind of where the researchers are, the invoices that have been submitted for the work being done. And yes, you're right. The first progress report, these were all executed by the end of October, so the first progress reports are due by the end of April. So July board meeting, you should have progress reports for each of them.
And it looks like almost all of them they've started their work, and I'd be interested to see where they're at. Excellent. Any questions from the board on that? Questions from the public on the research proposal update? Fantastic. Okay, so we're now going to go into the discussion of the U.S. EPA applicator, new applicator rules. And just to give a bit of a background, I know Susan's going to talk about it as well, but DPR, Department of Pesticide Regulation, being the state lead agency in this in California, they are essentially responsible for the implementation of this. So what they have done is they have begun to review what the requirements are from the EPA, and then on DPR side as well as the board as to what we already comply with and what we don't comply with. And the long and the short of it is that DPR has then basically told us where we don't obviously, or where they don't know where we comply with, and so now we have to fill in a little bit of background information, correct? Is that a
Yes.
Is it a summary of it?
Yes, that's exactly where we are. So in your board packages is what we received from DPR. In fact, we received a revised version last Friday. That should have been handed out to you as a separate handout today. The revised memo that we received on Friday identified 2 additional areas that the DPR feels that were deficient. I have started working with DPR. We're not required to provide them with our responses until September. I have a meeting set up with our folks and DPR for May 15th to have more discussion on this topic. In addition, if you have additional questions, we have a few folks from DPR in the room. Leslie Chapasanu, close? Okay. She's the lead at DPR, so if you do have questions for her now, we'd be happy to try and answer them for you. Leslie, you said you have another meeting with other states and the feds for when?
No, good. Come on up.
So for all the state lead agencies, the EPA puts on what's called a PREP course, which is an acronym, but I forget what it stands for at this current moment. But what it is it's a course where they're going to go over the state plan expectations and what we need to submit to them to show that our program in California is compliant with the EPA's new rule.
Okay. And so part of your preparation for that is to ensure that this board and specifically the licensees of this board comply with that, correct?
Right. So what I'm in charge of in my program is making sure that all of the regulations that are required, as well as the documentation for the EPA to approve our state plan, is in place and able to be submitted to the EPA to make sure that we're showing how our program meets those requirements.
Okay. And so I would assume as part of that, Susan, you're meeting with Opus, evaluating contracts and protocols from PSI to ensure that we're all compliance with this as well?
Yes, because some of the things that were identified was examination security for one topic. And I've already contacted OPEDS and got some information back from them. As far as PSI, of course, is in compliance because it's continuous monitoring, it's a secure site, requiring identification, things of that nature that we've already been doing since we started CBT.
Okay.
So, and then Leslie has already indicated that some of these deficiencies will merely require that we write a memo to DPR identifying how we are in compliance, and then others we may need some regulation changes, we may need some BMP changes, so we'll just continue moving forward.
Yes. And we're still waiting for some information too from the EPA as far as exactly what their expectations are with some of these items, such as the exam standards, as far as whether they want them explicit in regulations or a policy document to be submitted with the state plan. So we're still waiting for some of that information from the EPA. I should have that after the prep course that is coming up end of April, beginning of May.
Excellent. Do we have any questions?
Yeah, I do have a question. So one of the requirements, and it's on page 3 of the memo from DPR, and it states pretty explicitly that we're supposed to incorporate certain standards into our laws and regulations, and I'm concerned about the time frame for doing that. I'm not saying that that's incorrect. It's just like, well, unless it's like on the calendar right now, it seems. Or what's the game plan for being able to comply with actually getting those into regulation, and or if we're unable to actually finish the regulation, what
So I can explain a little bit about the timeline of the rule. So what we have to do by March of 2020 is we have to submit our state plan for California, and that needs to detail our plans for how we are going to implement this rule, as well, including things like proposed regulation changes or if there's laws or things like that. The EPA then has 2 years to review and approve that plan. The expectation is that we'll simultaneously be implementing those requirements. However, if we are not able to have them in place by March 2022, which is the EPA's deadline for approval, that's okay so long as in our state plan we're explicit about our timeline as far as when we can get it implemented, and the EPA approves that.
Okay, thank you.
So it can extend a little bit longer.
So essentially we have to have a plan in place to implement it by 2022.
Yes.
Well, no, not quite. So we have to have the written plan submitted to the EPA by March 2020.
Okay.
2022 is when we're expected to have it in place, as we're working concurrently with the EPA for approval.
Okay.
However, if we can't meet that deadline and we justify why we can't and when we will meet it, that's something that can be submitted for approval.
Okay, gotcha.
And I guess, and it doesn't seem like we have to be, I guess the requirement is that there's certain things that are in the federal regs that we just need to specifically refer to and incorporate into our state regs. So it's not like there's a lot of discretion on what we're going to do, and we don't have to have a sort of a long drawn out, hey, how do we do this sort of thing. It's almost not exactly ministerial, but it's almost like, here's what you need to do, and we just have to work the steps, right? So, okay, thank you.
Thank you. Any other?
Thank you.
So any further comment from the board on this? Any comment from the public? Okay. Moving on to the next discussion point. Discussion of the board's annual budget and possible action regarding WDO filing fee increase. This has been a significant topic of conversation, it sounds like internally within the board. Susan, did you want to describe where we're at and kind of what needs to happen from here?
Sure. What I handed out, and I have budgets here with us today as well. Marie, you want to come on up? So what's in your board package is if we do an additional $1 increase on top of the 50 cents that's already in the works and at Office Administrative Law. What I handed out to you today is our current projections with the 50-cent increase that is currently at Office Administrative Law. And Dave, Office Administrative Law has until May 8th, we calculated? Is that May 9th. Okay, May 8th, May 9th. That's the final day for Office Administrative Law to approve our current 50-cent increase that will go into effect on July 1st of 2019. So, Marie, do you want to explain any of this to the board members?
Okay.
Budget's position?
Well, she handed out an extra packet. For the.
Yeah, would you mind introducing yourself and
Yes.
the entity you represent, please?
Okay.
Thank
Well,
you.
my name is Marie Reyes. I'm with the Department of Consumer Affairs. I'm the board's assigned budget analyst. I've been working with Susan in regards to the numbers that is presented in front of you. There are two sets of fund condition. One was just sent, I think, distributed today. Am I correct? That one is the board's current fund, the current state. By the end of fiscal year 1920, if we don't do anything, the months in reserve would only be at 0.2 months, 0.2. So it's really in a very critical state at this point.
I'm sorry, and this is with the current 50-cent increase, not the way it currently is today.
This is with the current 50-cent increase
Okay.
beginning July 1st of 2019.
Excellent.
It's, so.
That says no fee increase.
And that's why I'm asking, because it says no fee increase on the
The
top.
reason why it states no fee increase is because the suggestion of the fee increase of an extra $1 for the WDO. The one that's in your packet is the one that's showing the assumptions with the $1 fee increase, with additional $1 fee increase.
Doing one, and then she's suggesting another.
Yeah.
Right. And the one is showing how it would be with the current increase starting July 1st.
July 1st.
Continue.
So currently, as I've stated, by 2021, the board would be in a negative by the end of the fiscal year, at a negative 0.7 months or 334,000. So the discussions have been going back and forth between us in regards to this, that we need to do a WDO fee increase. Reason why it wasn't done initially was because of the statutory cap that we had, correct, of $3. So we went in the cap, and then there was an increase, and then the cap was changed effective January 1st of 2019. But the 50-cent request has already been filed.
So when I brought this to you in April of last year, the WDO fee was already at $2.50 per activity. So our cap at that time was $3. So when I brought it to you April of last year, we knew that we could only go to the cap of $3. And then at the same board meeting, you authorized me to go back and have that cap raised from $3 to $5 and have that legislation added to our sunset bill, which I was successful getting our sunset bill. So then effective 1/1/19, the WDO cap went to $5. So while it's a little convoluted and fortunate that we could only do the increase last April at 50 cents, we didn't have any choice because of the cap at $3.
Okay, yeah, because it went from 250 and 3 to now to proposed 3 to 5. But now that's what it's going to be now without this additional $1. But with the $1, it's going to be 4 and 5. Correct?
Yes.
The fee is going to go up.
Yes.
To, the fee
it
is
would
gonna
go up to
$4.
4,
Okay.
and our max cap
Is
in
5.
statute it'd be 5. Right.
Okay, but again, to reiterate, what my understanding is that if we don't take this extra $1 on top of the 3 at the end of
2020.
At the end of 2020, this board will be running in the negative.
At the end of 2021.
2021.
Yes.
Okay, I'm sorry.
Fiscal year 2021.
Okay, at the end of fiscal year 2021, this board will be in the negative. Okay.
And I'll just try to mention just a couple of reasons for the expenditures going up. Of course, OAH in recent years has went up for administrative hearings. Of course, our Attorney General's cost has been going up the last couple of years. With one is a lot more statement of issues being requested and filed. And then in addition, we are currently working on our business modernization plan for a new IT system that would be accessible online to the industry for renewals, for address changes, for doing all that stuff online. So that our business modernization plan, the projection for that is at $1.8 million for a new IT system to replace our 2 legacy systems we currently have. And that we're supposed to go live with on 1/1/21. So that is built into these numbers as well. So those are some of the things that we're facing and we have been facing.
Thoughts from the board? Please.
Yes, can you, since this is all on the back of the branch 3s, can you explain, is most your actions and enforcement issues regarding branch 3s, because they're asking to pony up most of this money, is there any other fees or items?
No, absolutely. Absolutely. Probably 90%, maybe even more, of the complaints that we get are in regards to branch 3.
Okay, so your entire budget increase is totally around from the branch 3s then?
Yes. So. For the most part, yes, because our other fees, I didn't provide an actual fee schedule for all the other fees, but the other fees are very minimal in comparison. Historically, the WDO fee has been adjusted to keep our budget in balance, up and down over the years. The last increase that we had, excluding the current 50-cent increase that we're doing right now that's at Office of Administrative Law, the last increase that we had was on 1/1/2010.
Into your projections, it's very concerning that there's a number of companies that aren't filing WDOs, which we have in closed sessions all the time. What's your thoughts on that? Is the board enforcing WDO reporting, or?
Yes.
You think you're pretty up to date? Because it looks like the numbers are pretty actually stale from the highs of WDO reporting.
They are a little bit stale, yes. In closed session, as you mentioned, that case was very successful. We've had other couple of cases that have been recently very successful where we have actually taken licensing and disciplinary action against companies merely for not filing WDOs, and we've been successful. So hopefully that word will get out to the industry as well. And of course, we're doing our routine office record checks and stuff like that. And Ronnie monitors our WDO filings and what companies are not filing on a regular basis. And then we give those targeted companies to the specialists and have them go out and check those records individually.
Okay. So you feel primarily a lot of these costs are outside of your control that you have to budget for?
Yes. When it comes to Attorney General's Office, Office of Administrative Hearing, the new business modernization, new IT platform that we'll have soon, those are.
Okay, thank you. I have no further questions.
So your options are, Simeon, you might be able to identify this a little easier than I can, but your options are you can go with the recommendations of the Budget Office, or you can go with not doing anything at all, or something in between what we are going to have right now with the fee increase going to $3, between $3 and the $4 that is being recommended. What?
Well, and the other thing,
Microphone.
I don't know if it's been
Microphone?
discussed. Oh, sorry. Is Marie is recommending that this be an emergency regulation, which would go into effect July 1st, if we can pull it off. So Sabina has thoughts on this too. I'm guessing by the look on her face.
I didn't think that we really qualified for emerging. I didn't think that this met the criteria for emergency regs. It does.
We'd have to look at it a little closer to see if we qualify for that. You did get the last one packaged through rather quickly, so that is a good sign.
It took a year, and we're still counting. Okay.
Sorry. So yeah, we would have to work with Marie to pull the numbers and to see if it qualifies for emergency. As it stands right now, though, you don't have language in front of you today, so you wouldn't be approving text to be moving forward for a regulatory change at this point.
I'd like to hear from the audience on this. Come on, public. You guys got to have an opinion on it.
Mr. President, members, Chris Reardon again, PCLC. I'm going to be very measured. I've been there, done that in terms of, to be honest with you, regarding the challenges with just the cost of doing business with the state. It just is. I know I think I remember the 2010 fee very well, once upon a time. It's a pretty good track record now raising those fees
For
over
10 years.
For 10 years.
Almost 9.
Pretty darn good, if you ask me. But having said that, I think our industry needs to understand it's probably going to get worse before it gets better in terms of cost, in terms of pensions, in terms of your cost of doing business. You can do the best you can, but I think one of the things that we're going to have to pay attention to as an industry very closely is what this budget looks like, 22, 23, 24 down the road, because I think it's going to be is challenging, or maybe more challenging, in terms of not only for this department but a lot of departments, in terms of just the infrastructure to do business. And guess who it's passed on to us?
What do you think the response from the PCOC members are going to be?
Oh, I can imagine what the response would be. I think there's going to be a concern, but I think one of the things that we're going to maybe talk with Susan about in council is how we sort of phrase that, and remind them too that, by the way, this hasn't been in 9-10 years, and we need to be good stewards, and we're spending our money wisely, and sort of all those factors. But it's the realities that we live in. But we just want to make sure, and this isn't, the challenge is to make sure that if the money's being spent wisely and prudently and all those sort of issues. So it's incumbent upon us to sort of, not only me, but other folks understand how we're spending our money at the board.
Okay. Thank you. Todd, we're going to say something?
So I'm in agreement. Todd Vadine, Terminix. I'm in agreement with Curtis Good's point about the Branch 3s bearing the brunt of this fee, when in fact it should be, in my opinion, across the board for all licensees. I look at a 50-cent increase to possibly $4, even possibly $5 per activity for a company as large as, say, Terminix or Orkin. That's a lot of money for the number of activities that we do, or small companies. That's a significant percentage potentially for an increase. While I think increase is probably necessary because the cost of business is going up, has other thought been given to raising fees in other areas, such as applications to take exams or renewal? For example, to renew a pest control advisor license is $240 compared to $30 for a FR license, or $120 for an operator license. Perhaps our fees there need to come more into alignment with DPR's licensing side. Thank you.
Curtis here. Curtis Good. Just for clarity, I was asking for clarification that the enforcement level on this board is generally, which I knew the answer to that question before I asked it, but it is above 90%. So the Branch 3s do bear most of the burden of that cost. I think spreading it around, and I don't mean to speak for our registrar, but trying to put it into some other categories, there's just not enough of individuals to raise enough revenue. And I would share to you, Todd, from my experience being on the board, and when we go into these closed sessions, I was never prepared for what I was going to get in closed session, and I could absolutely tell you it is a very costly endeavor for this board to prosecute and find those at fault that make a great deal of mistakes for our industry. So it is a very costly portion of what the board's activities are. And I just went through it this morning, so I can absolutely understand. Do I have to go back and write a larger check? No, but I clearly do understand the reasoning for it. It would be nice to have a way that the board would be able to control those costs some way and just say it's just out there, but because it is kind of mind-boggling that at the same pace. My concerns are more around, are we really collecting all the fees? Are all the WDOs being filed? And I think we're missing a lot of opportunity there. I just think there's some abuse there. So that was kind of more the question I was asking of our registrar, making sure that Because I think there could be some greater fines on what I would propose to see greater fines on those individuals that choose not to file reports. I'd like to see them bear a lot of that burden, since that's where that cost is going to. Thank you.
Thank you. Susan, you look like you were going to say something?
Nope.
Okay. Any other comments from the board on this?
So since we do not have language that we're going to be voting on today, if the board gives us indication that they do want to move forward with this, we'll do probably a teleconference meeting here pretty quick to go ahead and put it into effect. Yeah?
Because we didn't actually put 1990, okay.
Okay, so there's no action then do we need to take today then, correct?
We do need to give staff some indication of what we, which option we want. I'm in favor of raising the WDO fee by $1.
Is that a motion?
No. Well, I don't know. Do we need a motion, or we just
Not
you
necessarily.
Just need a sense of
We can bring you back language with the specifics, and then you can determine at that time also how much the increase should be.
Okay.
We can also talk about maybe even having a fee audit. I mean, someone else mentioned looking at all the licensing fees and renewal fees. Maybe it's, and I don't know when the last time those are raised or audited, but maybe just looking at them and seeing if any of them else need to get in line with DPR or whomever.
Okay.
Curtis?
Yeah, so before our next meeting, if we could, I appreciate this fund and this analysis, but is there any way you can go into this a little bit more in depth so we see exactly what these costs are and how they're really being broken out more? Because we were just kind of handed this sheet and we didn't spend much time. I just like a real clear understanding of the costs and what we're really paying for.
Okay. So do we want to, does board members want us to bring this back at the July board meeting with much more detail and language and actually a breakdown of expenditures?
I'd like to see that.
Okay.
You guys okay with that? Do you care?
I'll go along with what the rest of the board wants to do on this. So,
Mike, what do you think?
Yeah, I think that's an excellent idea, is to bring a little bit more information so that we can make sure that we make the right decision whether we go $1 more, on the raise.
Okay.
At that point in time, would you also be able to bring us language that we can vote on at that point?
Absolutely. Of course. Yeah.
Good, right.
Marie, any comment?
So we're waiting until July, for the July meeting before we proceed with any of this? I just wanted to make sure I'm in the same understanding.
Well, and that's why I was looking for clarity from the board members. If we want to immediately move forward and have possibly a teleconference meeting and bring that information back to you, or delay this to July, or I was looking for direction from.
Now, let's see if we can move forward with a teleconference, because it sounds like due to timing we may need to move on this a little sooner than later.
That's my concern, yeah.
Okay, and then but in the July meeting, I would like to see a little bit more kind of a breakdown of why, kind of where the spending is and breakdown of the budget that we talked about.
Well, do you want to try and schedule a teleconference board meeting within like the next 3 weeks, and we can bring greater detail to you along with options and fund conditions and language?
Yes, do that.
Yeah.
yeah.
I'm sorry?
An expenditure report? At
Yes.
that time? Yes.
Obviously, they want to have it
Yes.
detailed expenditure reports as well.
Provide you a historical to show.
Perfect.
Dave?
Yeah, I think it's better to have the information earlier, and then whether we make a decision earlier than July, at least we had the.
You'll have
discussion
everything in
about
front of you.
what the
And then, of course, we can have it on the agenda again in July to
Just in case.
And have it available for more of the industry. If there's more participation, then at a teleconference meeting.
Okay.
Yeah, PCLC.
That sounds good. Okay, so we will have a teleconference then on this issue in 3 or 4 weeks, or whenever we agree upon it.
Okay.
Thank you for your time.
Thank you.
Thank you, Murray.
Okay. Do we want to break for lunch or want to keep moving? You guys want to break or you guys want to keep moving?
Keep going.
Okay, let's keep moving. Okay. Now we have Opus. A recommendation to eliminate continuing education challenge exams. Susan, where is this coming? Kind of give us a little background on this and what specifically you're looking for from us.
Historically, the challenge exams have been written by staff. So obviously that's a problem.
Yeah.
In addition, in looking historically at how many individuals request to take the challenge exam, it's less than a dozen each year. So then I asked Office of Professional Examination Services, OPEDS, I asked them for their analysis and their recommendation in regards to our challenge exams, and would it be beneficial and cost-effective to have Office of Professional Examination Services take over our challenge exams and then have them also CBT. So the recommendation I got back from Heidi at Office of Professional Examination Services was to eliminate our challenge exams. There are enough continuing education courses approved and available even at low cost for industry in order for them to be able to comply with the requirements of 12, 16, 20, or 24 hours in a 3-year period. So their recommendation was to eliminate the challenge exams. So in your board package is language, statute, along with regulatory that we'd have to have amendments to officially eliminate the option of having challenge exams available.
Okay. Comments from the board?
I don't have a comment, but if there's so few individuals taking advantage, I would like to make a motion, if so, to just discontinue it or eliminate it.
What, got a question for Sabina. What kind of motion do you need? Do we need something specific to the language that was provided us?
Right.
That'd probably be.
So we have two different things going on here. We have regulations and we have statute. So, yep.
I just wanted to say, if you're gonna vote to move forward on the regulation, I'd like to include this in the continuing education overhaul that you guys have already authorized me to do, that I've been working on. It's just a natural fit to go ahead and put it in with that. So.
Yep, you can add it in whatever packet you want.
Just wanted
And then for the statutory changes, I don't know what your plan would be is there a sunset coming up or anything like that where you can, or you just finding?
Well, we just did that sunset last year. So I can try and find an author to carry this. It's too late for this. I mean, I might be able to get into a bill.
Can I get you to use your microphone? Thank you.
Sorry. It's most likely it's too late for this legislative session, but I might be able to get into a bill this legislative session. Sunset we just did last year. Usually that's used for cleanup things. So I would have to move forward next legislative session to find an author to carry it.
Right. So, So you would have a motion for her to pursue that legislative change that you see in your board packet, and then we would also have that regulatory long motion that you like so much.
Yes.
Curtis, do you have any thoughts on this?
I would agree that not very many people taken. I was actually going to go back and look and see how many people have failed it, because we're really not serving our licensees very well by having an old exam out there. Essentially, we're possibly setting them up for failure, because if somebody just got a recent license and then they chose to go take this exam that has 20-year-old information, we're probably not serving them very well by having it available. But I did like having it as a vehicle, but I certainly understand the cost with so few people taking advantage of it.
Right, the cost is, it's so costly to have OPEDs rewrite this exam and then have them, same thing, do workshops to keep it updated, et cetera, et cetera. I think requiring the continuing education for all licensees is a much more cost-effective route for the board.
Any comment from the public before we start crafting motions? Okay, I got crickets. So it sounds like we're all in agreement. So Sabina, can you give us the motions that somebody needs to give, please?
Well, Mike, there's a motion on the table.
Well, his wasn't
Mike,
seconded, though.
Okay.
Right, Mike.
Nobody
Mr.
seconded Mike's motion.
Yeah.
Correct, no one did.
What was that motion?
Yeah,
It was to move forward with eliminating the exams.
Oh, okay. So, you can amend that motion if you like, or withdraw it. We can amend it to use it for the legislative changes.
Let's do what's necessary and correct.
Okay, all right, so Mr. Duran's motion would be to eliminate these examinations in statute?
That is correct.
Okay, so we have a motion for that.
Okay, did we have a second?
Second.
Okay, we have a motion and a second. And that would be giving authority to your executive officer to pursue those changes in the statute, the legislative changes.
That is correct.
Okay. Vote. Taryn Van Steenwyk.
Yes.
Dave Tamayo.
Yes.
Curtis Good.
yes.
And Mike Duran.
Yes.
So now we need to tackle the regulations portion of this. So we would have, as you see in your packet, you'd have two sections that would have some deletions in it, 1948 and 1951. And that language is in your packet. And should you like, I can read your motion.
Please.
I move that we approve the proposed text for a 45-day public comment period and delegate to the executive officer the authority to adopt the proposed regulatory changes if there are no adverse comments received during the public comment period, to follow established procedures and processes in doing so, and also delegate to the executive officer the authority to make any technical and non-substantive changes that may be required in completing the rulemaking file.
You know, that's exactly the motion that I intended to make. Thank you very much.
Did she
So I
take the
will
words
make
out of your
that
mouth?
motion.
Second.
And vote. So Darren Van Steenwyk.
Yes.
Dave Tamayo.
Yes.
Curtis Good.
Yes.
And Mike Duran.
Yes.
Thank you, gentlemen.
Fantastic. Moving right along. Regulations update. Can I just go straight to Dave on this one for the CEU stuff?
Yes, absolutely.
Yep, so I've got everything all written. It's ready to go. So I'm just going to include the challenge exam stuff that you guys just authorized. The other thing about it is, Susan mentioned we have a meeting with DPR on May 15th. Before I notice it for pre-review, I'd like to show it to you guys to see if it complies with the federal standards. And Darren, I wanted to ask you, is this the same? You remember the first roadblock we hit with the CE proposal while we were waiting for the EPA?
Yeah. This is the same one. At this point, we just no, it's actually different, because when it first came out, it was very detailed and lots of ambiguity, and then they came out with a revised version. And so the significant roadblock we ran into was with the first one, not with this current version. But as part of our discussion, we were looking at it. We didn't see any obvious issues with it, but DPR may beg to differ on that one, and so,
That's what
I'd like to see their opinion on it.
Okay, yeah, so-
before we put it for public opinion.
So that's May 15th. I have the ISR written, I have the notice written. It's literally, I just need to hand it to Sabina, but like you said, get DPR's take on if it meets the...
Can we get it to DPR to review that before May 15th, or?
Sure.
And then, okay. So I'd like to do that, please.
Sure.
Leslie, do you have time? I mean,
What are you doing this afternoon?
I can certainly do my best to take a look at it as quickly as possible and let you guys know if I see any concerns. I do know that the first proposed rulemaking had some specific requirements about when CE had to be completed, how many CE units had to be completed, and things like that that are not in this new implemented rule. So hopefully it should be okay, but I can definitely take a look at it and see if there's anything that I think would be a red flag or a concern to the EPA as part of our state plan.
Yeah, it'd be great, because I'd like to get DPR to look at it before you pass it off to OAL,
yeah.
because if they're gonna have to make changes to it, I'd rather do it rather do it sooner than later.
Agreed.
Yeah,
I'm pretty sure it exceeds the federal standards, but...
Everybody here assumes, but we'd like to get a stamp on it just in case.
and we may as well get this done first before we even send it up to legal for their pre-review to even get the ball going.
Yeah.
Another advantage of me having it a little bit sooner is if there is something that we have a specific question on at that prep course that I was talking about, that's our opportunity to speak directly with the EPA. So if we see something, hopefully maybe I can get some answers then as far as whether or not anything may or may not be of concern.
Fantastic.
Yeah.
That's a long time coming. The CEU stuff is a long time coming.
Of course, the minute I got done writing it, the DPR stuff came down. I just couldn't believe it. But so anyway, the other thing that we already talked about is the WDO 50-cent increases at OAL now. Their deadline is May 9th. So.
And then I know that it's not in a board packet. Maybe you can comment on it, at least update everybody. 1970.4. What's going on?
I have no update on that one. It's been pushed to the back burner for the time being. I mean, Sabina came back with suggested language. I passed it off to Robert Lucas to review, and that's where we are with it. Our staff.
Because I know that Sabina's language drastically overhauled the whole section, right?
I think it made statutory changes too.
It made statutory changes as well.
Yeah, and so it's taking a little longer to get through. But if there's a way that we could
step on the gas there,
just not leave it where it currently sits. Yeah, if we could continue to move it through, that's another thing that would significantly help help the consumers of our industry.
Yes, sir.
Okay. Any other questions on the regulatory update from the board? Okay, from the public? Mike, you want to say something? You sure? Okay. Okay, so legislative update. We've got a handful of bills that will impact us this year. Susan will take some, I'll take others, but Susan, you want to go ahead and start it?
Sure.
AB 193.
Actually, Sabina, did you bring this one to our attention?
So this is your fault. Okay. Microphone. What is just can you give us a brief summary of this bill and why we care about it? 4 words or less.
This is the bill that will require each board to do a comprehensive review of all licensing requirements for each profession. And then after 2021, every 2 years after, then would require them to submit an assessment on the board's progress for implementing different policies and procedures to facilitate license portability, particularly for military.
Okay.
That's the bulk of it.
Is there anything we need to do with it?
Well, the board can always take a position on a bill. The board can just watch it. We can report back.
Is this a bill we like, or is this a bill we don't like?
Well, I think license portability for military members is very important across all professions, but that's just my opinion.
Okay.
I think, when are you guys meeting again? July?
July.
You're gonna be over by then?
It will either move forward
Yeah.
or not at that point.
Right, and and if we are gonna do a teleconference, if anything changes in any of the bills that you see today and that you talk about or are interested in or want to hear more on, we can add it to that agenda, and then you guys can take a closer look at it then, especially if it's in a watch status.
Okay. So it sounds like we just want to leave that one on watch status right now. Anybody? Okay, that's your recommendation at this point? Okay. What about AB 434?
Okay, so AB 434 it was going through the legislature last year and became effective on 1/1/19. This bill is in regards to state web accessibility in compliance with ADA requirements. So, Dave, you like this bill. You want to elaborate on this one?
So this bill didn't make any changes to the ADA. What it did was require the directors of several agencies to certify by July 1 of this year that everything on a state website is ADA compliant, which essentially means that a text reader can recognize whatever's posted and read it to people that are vision impaired. So we're going to be making some changes to our website, or I should say DCA's IT department will be, to make it compliant, so the website will look a little different. And then we can no longer post scanned documents to the website because they can't be read. So there's going to be some challenges with getting stuff up on the website going forward. So we just have to make sure we ask for source documents, basically converted Word documents. And then there's other challenges with posting. For instance, tables, like the licensing stats, need to be configured in a certain way for it to make sense when it's being read. So
that it's not just garbled on our website when it's being transcribed by this reader for visually impaired.
Okay.
So we are required to be in compliance by July 1st of this year. So we're working diligently with DCA and IT.
Okay.
So the inability to put in scanned documents, is that going to pose a problem? I mean, it seems like there might be some things that we get in hard copy. To what extent do we already have scanned documents?
quite a few. The proposed decision, in anything from the AG's office.
Everything
usually
from
have-
the AG's office, correct, is a scanned document right now.
But that
So-
said, DCA has an agreement in place with the DAG and with OAH to provide documents that are compliant. And from my understanding, the game plan is they will post it with the signature, meaning the scanned document, alongside a compliant document. So it will be posted twice, one with the signature, one that can be read. So, and that's the game plan with all I mean, there's documents we get from Office of Administrative Law, for instance, that are, you know, obviously have signatures and have to be scanned. So that we're working around it.
We're working on it.
But
virtually, it looks now like most documents will be posted twice, unfortunately. So kind of double the work in order to be compliant.
And DCA, OIS at DCA is doing a lot of the heavy lifting with this. It falls to them a lot of the time when we ask them to post something, they make it compliant. So it's added significant amount of work for them.
So it sounds like it's going to be more work, but it's not overall going to be making things overall less available to the public. It'll still be available to the public, but it'll just take more work to make that occur. Okay. Thank you.
Okay. AB 613.
This is actually. Go. I can pass. And it really was an interesting bill. It actually made me do math. So.
You had to do the maths?
That's why I want to talk. So it allows boards and bureaus under DCA to increase any of its authorized fees once every 4 years by an amount up to the consumer price index for the preceding 4 years. See where the math comes in. So, and this would be without a regulation. So how you just voted to increase any kind of fee. If that fee fell under this, you wouldn't have to go through that type of process. You would, if you were requesting an increase pursuant to this, you would then provide all your calculations and your request to the director. The director would approve it. And there's these different circumstances about when the director won't approve it. So the board has, if the board has unencumbered funds that are equal to more than the board's operating budget for the next 2 fiscal years, or the fee would exceed the reasonable cost to the board to administer the provisions the fee is paying for, or the director determines the fee increase would injure public health, safety, or welfare. So it's kind of interesting in that regard. So the CPI, as a measure of what I found out was the average change over time in prices paid by urban consumers, right? And so I did kind of some math, unfortunately or fortunately. So I kind of pretend. So April 2010 to 2014, the increase could have been 8.3%. So it's not very much. It wouldn't be, a large amount. 2014 April to 2018 April would have been 10.3%. So it would allow a board, if they're maybe in some kind of financial dire straits, to do a quicker type of very small fee increase.
Without going through any sort of regulatory or statutory change?
Correct.
Okay.
So this would, so like the WDO, we have a cap on it. So this would, if this passed as it is, then that would effectively remove that cap, or is that not what it's doing?
You know what? So only certain regulatory fees fall under this. So I'd have to see how that is, but I know different penalties, administrative fines and stuff are not included in this, so we couldn't say all of a sudden we're going to raise our citation to, pursuant to the CPI, right? So I don't know how your WDO, what that is. Is that just a regulatory fee, I'm assuming? So it could potentially have been used for that. But it would only be 10.3%.
But to answer your question, it is meant to exceed the fee cap. It's without regard to any fee caps that are in place.
It operates outside of everything.
Is this one? Was this last year's or this year's? Okay. And do you know the current status of it?
I can look it up real quick. Other boards have been just watching this.
Spina, I heard that the author was looking for support from programs on DCA.
Mm-hmm.
I'm out of that loop, so you are probably way more in that loop than I am.
If other boards are just watching it, I'd like to just watch it
I can
as
only
well.
I can only respond to.
I went to a legislative roundtable last week, and this was discussed quite a bit. There's a lot of questions, like Dave just asked, about how it would work in practice. How does it work with fee caps? How does it work with OAL having our fee recorded as one thing, and then we're charging something else? So they're planning. They're planning on having a stakeholder meeting. I think the author is. So, yeah, continue to watch it, I guess.
It gives you flexibility.
Yeah.
You know, that is a good thing.
Yes, it is. And I went to the authors and asked those questions, but I didn't get a response yet. Like, how is this going to affect our fee caps in statute and our regulations?
Well, I think that if the legislature is willing to give its regulatory agencies this sort of flexibility, I think that's a good thing, provided that that there's still sufficient opportunity for the public, including the regulated community who's going to be paying the fees, to weigh in on it. So,
right.
You know, obviously I wouldn't be in favor of just carte blanche, but I am in favor of sort of streamlining it, because I realize it takes so much effort to get something through the legislature, and to me it doesn't seem like the legislature should be involved in, okay, what's the level for the WDO fee? It just seems like they ought to be thinking about other things. So.
And, you know, the industry and the public would have that opportunity, because Susan wouldn't be just wanting to put together a fee raise without coming here to you guys first. So there would be that opportunity at meetings.
But the law would allow her to, though.
Well, no, you guys would have to approve her action.
Okay.
So they would still have that. It would be different than the regulatory process, of course, with the 45-day comment period and the hearings and stuff, but there would still be public meetings.
Okay. So it wouldn't allow any one person to unilaterally raise a fee, regardless of how much it is, to unilaterally raise a fee without going through.
Right. She has to be directed to do something.
Okay.
Well, yeah, it says it's the board. It doesn't say the executive officer. So, cool. So I think that it's actually a positive thing.
Okay. So.
You can take a position if you'd like to support or watch, or.
If everybody else is watching, I would recommend that we watch.
I didn't say everybody.
Let's say we watch.
And we can put it on that teleconference agenda if I hear anything about the stakeholder meeting. Bring you guys some more information about it. So
that'd be great. Thank you. AB 1024, home inspectors licensing. This is something that has been talked about in the past. Trying to put home inspectors under the CSLB. That's what this version of this law does. The State Contractors Board. Now, this is something that this board, has had multiple discussions on and dealing with, and the crossover between home inspectors and its licensees. However, after talking with some people trying to figure out where this bill is at. It currently is still in committee. It did make it out of committee. I believe that the author is continuously, continuing to look for some changes in language, but at this point in time, it's still sitting in committee, which means that if that doesn't happen in the next probably couple weeks or so, this one will not go anywhere this year as well. 1788, This is from Bloom. This is a ban in second generation anticoagulants in the whole state, and a ban of first generation anticoagulants on all state owned property. There is a handful of specific exemptions that would be provided in this. Although the specific exemptions are apparently applied only to, or what we can interpret, only to second generation, not first generation, and specifically regarding agricultural sites, agricultural activities, basically a agricultural food production site, slaughterhouse, cannery, and it specifically mentions factory, brewery, or winery. Last year, we took a stance to oppose this bill, and we wrote a letter. What I would like to do is to do the same thing this year. That this board takes a stance to oppose this bill, and write a letter to the author's office stating that. What does the board think?
Do we have a copy of the letter that we wrote last time?
I'm sorry, I did not bring it.
One of the things one reason why I would like to oppose this bill is because the specific issues that this bill is meant to address, this board just approved a $350,000 research project to answer those questions, and that is what a significant amount, kind of the background as to where the proponents of this bill are saying that there's issues. Dr. Neve Quinn is trying to answer those questions, and this board just made that significant investment to answer those questions. And one thing that I would like to see is that research be completed to be able to, again, address some of those questions regarding the pathways that Dr. Quinn is trying to determine as well. Okay. So I make a motion that this board takes an opposed stance on AB 1788. Okay, so we have discussion.
Well, it sounded like there was some condition, and it's not reflected in the motion, as far as that there's, you feel that there's insufficient evidence as to what the pathway is. So, and it, anyway, it doesn't sound like that's actually in the motion.
Mike, what do you think?
I think that a letter is appropriate, stating the consensus, of this board, and also letting them know that we do have a research committee working on it and trying to get the correct answers.
Okay, I like that. We can, if this board moves forward to oppose, we can write a letter specifically stating that. No, Dave?
Well,
I'm sorry.
I would offer an amendment that that the board is in opposition to it because we're currently supporting research to better understand the problem.
I will take that amendment. Will you take that amendment? Absolutely. Okay. Yeah. So the motion as it stands is to take a position of opposition to 1788 on the grounds that this board is funding research to determine the kind of the pathways of second generation anticoagulants into wildlife. Comments from the public?
Mr. President, members, Chris Reardon again, PCOC. I might offer also an important point in this too, in terms of what you just described in your amendments. The Department of Pesticide Regulation is also conducting a formal reevaluation. You just started about a month ago. That's an important component of this because that's how the process is supposed to work in California. If they have a product with an active ingredient, under the law, under continuous evaluation, the department is required to do a reevaluation, and that's what they're doing. So our view on this is not only do we not have, we're looking at additional data, but now this bill is sort of the cart before the horse, that we're going to impose or ban a product even before we've done a full evaluation. So I think it's important to note that I hope the reevaluation will be recognized as well.
Thank you. Yeah, in the letter, we can definitely recognize that. Any other comment from the public on this? Professor Skelton, did you want to say something?
No, sir.
You sure?
Positive.
Okay. Can we take a vote, please, Susan?
Darren Van Sneewitt.
I support the motion.
Dave Tamayo.
Yes.
Curtis Good.
Yes.
And Mike Duran.
Yes.
Okay. I'll start working on a letter to get it to the author's office before we send it. Susan, Sabina, can I send that out to all of the members of the board to let them look at it?
Why don't you send it to the board first?
Okay. I can do that. The process was singing, write it, send it to the board to get feedback, and then we can then. Yeah, okay. Perfect. We can do that. Okay. And then SB 53.
It looks to me like a spot bill, but maybe you have more information.
Just that, I think we've seen it twice before now, trying to change, make 2-member subcommittees subject to the Open Meeting Act. So it does a lot of things, and accountancy has already formally opposed this bill. And some of the things that they cited in their opposition letter was that it would prevent 2 board members meeting together with legislatures. I mean, anytime 2 people got together, then they would be stopped from doing that. They would have to have an open meeting. So it would change a lot of the way you do business.
What's the kind of the status of this bill? Is it gaining momentum? Is it something that is?
They've tried twice before. His status. Let me see.
So essentially, that means that any time that say my path across with Dave's would have to be considered part of an open meeting.
It's been ordered to a 3rd reading on the 9th. It's in the Senate right now. Appropriations. Last committee action was the 8th. That's all I got.
But again, to reiterate, that means that essentially Curtis and I cannot be in the same room.
Right.
Well, does it actually mean that, or it just means that you can't be discussing any of the board's business? Because I'm familiar with the Brown Act, which
right.
Refers to local government, and
right.
it's not that restrictive.
Right. So any of the business that you might do as a subcommittee, if you have 2 members,
right.
It would have to be held with the under Bagley-Keene.
Yeah.
You can go to a cocktail party or whatever, your birthday party.
Right. So we can be in the same room. We just can't. Under the effects of this bill, we wouldn't be able to say anything about the board's business. I think it's unnecessarily restrictive. I think that there's actually public benefit to having the ability to bounce an idea off of one other board member. I think it enhances our ability to serve the public well, and it certainly doesn't allow for us to conduct, really make decisions in private. So I would I would offer a motion that, to express our opposition to the bill.
Who was the second there?
Okay. Further discussion? Okay, input from the public on this one. Okay. Susan?
So vote is Darren Van Steenbeck.
Yes.
Dave Tamayo.
Yes.
Curtis Good. And Mike Duran.
Yes.
Sabina has offered up that she will get the draft from another program. And then I'll forward that to you, Darren, for your approval.
Fantastic. Okay, moving right along. Before we totally leave all the legislative update, is there any more input from the public on that agenda item? Kind of moved through them all. We didn't open it up. I didn't ask for public comment on every single one, but now's a good time to do that. Fantastic. Future agenda items. Who wants to hear what in the future? The silence is deafening. We've talked about it a lot today. Well, we are talking about, so we will be doing a teleconference for us to talk about the Wdo fee increase, and we will be noticing that and potentially having a few other agenda items on that based on based on subsequent conversations. I would like to see, actually, at that point in time, an update on the EPA applicator certification. Yeah, in the July meeting, because it sounds like there will be a handful of meetings happening between now and then, and so I'd like to see where we're at on that. What else? Who else? What else do we want to talk about in at the July meeting? Yeah. Thank you. Yeah. Updates on any, specifically the two legislative bills, or actually any of the legislative bills that we want to, that we either want to watch or took a stance on, kind of where those are at. Dave, you think there'll be an update on CEUs by then?
Yeah, definitely.
Okay. So
by July?
Yeah.
Yes, certainly. Yeah.
Okay. So we'd like to see an update on that. Anything else? I'm sure there'll be something will come up between now and then, but okay.
You probably would like an update on 1970.4, I'm guessing.
That's a given.
I know.
I'm gonna
McKenzie would like one.
I'm gonna ask you about it, whether you are gonna answer me or not. Okay. Moving on, public comments on that. Okay, so moving on to board calendar. We have the board meeting in July, the 17th, 18th, and that's going to be in Claremont. And then we have October and back in Sacramento, 23, 24. And then at that point in time, we are also going to be doing, we'll work with Susan to make sure that we have the stakeholder meeting on the OA for the applicators exam surrounding that time as well. And then we have the meeting moving into next year. I do know that we did talk about, so we were able to move the meetings from four times a year to 3 times a year, correct?
Yes. Currently, you could have three times a year.
Okay.
Now, they just changed that currently, you're required to have 3 meetings per year. And now it just changed on 1/1/19 that you're only required to have 2 meetings per year. One must be in Southern California.
Okay.
So you could virtually only have 2 meetings, but if you want to cut it down to 3 meetings.
Okay. Just because I know that we talked about moving the April meeting up to beginning part of March, so we can
Because of
potentially address any legislative issues,
Right.
kind of before everything goes through the goes through the policy committees. But that would then potentially move, making scheduling 4 meetings that year would be a little difficult. That's what we talked about, right?
Yeah.
Okay, so how do we want to do this?
Well, I
want to move to. I'm sorry. Go ahead.
I noted that on the 8th, I was wondering if in July, I'd prefer if we could just try to have that meeting on just the 17th. And I don't know if we have such a busy calendar that we don't think we can accomplish that. We've gotten pretty good at getting through our agendas in
one day.
Yeah, and
preference would be Tuesday. Preference would be Tuesday all day on the 17th?
The Wednesday.
Wednesday the 17th all day.
Yes, I'm sorry. I'm
Curtis?
sure that's doable. There was quite a bit on this agenda. I mean, we did start at 8 versus starting at 9 o'clock. But it seemed to work out fine this morning, and that was a pretty lengthy agenda with quite a few topics. So we should be able to do that in July.
Mike, how you doing with that? You doing okay with that?
No, I can handle it.
Okay. Okay. So let's do it one day in the 17th. Or
Yes.
Yeah, as much as we can. Depending upon
Right.
how many reinstatements.
Right.
And
How many
whatnot.
reinstatements we have, but that's probably doable.
Okay. Cool.
While it's under discussion, do you want to try and plan the teleconference meeting now while the 4 of you are together?
Sure. When do we need to have it by? Or when's the earliest we can? When would be a good time?
It has to be at least 10 days out.
Okay. Well, we probably won't be able to do it 10 days. What do you guys think? When can you do it? And then Susan, are we going to have a location here that people can attend if they would like?
Yes, that's what we normally do. Is we
Okay.
have normally it's the Lake Tahoe room that we do here.
Okay.
So most likely you and Dave would be here,
Mhm.
and then we would notice Curtis' location, Mike's location, and Rhonda if she's available and participates.
Okay.
Does mid-May seem workable?
Sure.
Sufficient time? Afternoon of the 14th or the 15th?
15th works better for me.
At 1 o'clock?
Curtis? 14th or 15th?
The 14th I'm available.
Okay.
14th at 1.
Mike, how about you?
I think I can handle that.
Yeah, because I can make the 14th work.
Dave, can you make the 14th work at 1?
Yes.
Okay. Okay, so the 14th at 1 o'clock?
Yeah.
Okay, and for the audience's sake, of course, we'll have this location open, or their locations will be available for you to sit in.
Okay. At 1 o'clock. Okay. And then how do we want to handle January? Do we want to do a meeting in January?
Do you want to combine the January and April and have it early March? Is that what you were thinking? October is required because October is our annual meeting. So we must meet in October every year. Otherwise, it's pretty flexible.
I don't know. Board members, what do you guys think? Or do we want to keep it 4 times a year just due to the amount of closed session stuff that we end up dealing with?
Just hold it and see what it looks like.
You want to put a meeting in January and see what it looks like? Okay. How do you guys feel about that?
Sorry, if we ran into a deadline of the 100 days, then we would have more mail votes go out to you.
What do you guys think?
January tends to be, well, it depends on which week in January, but if we don't need to do it, that's, you know, prefer that we didn't, but.
Well, it's too, sorry, but
just don't know yet.
Right. I mean, it's too early for legislation because bills have to be introduced by usually about the third Friday in February. So you don't really know what's going to be coming up in the January meeting. April, obviously, like Darren said, it makes it a little too late because by then they've already moved on. So
does sometime in February seem like a better time, or is
It'd be early March is when it would be.
early March?
Mike, what do you think?
If we could do away, you know, not having a meeting in January and have it early March, if that works best. But, you know, I'm game for anything, four meetings, 3 meetings.
Curtis, what do you think?
Sure, let's try it.
Okay, let's try it. Early March. Let's look at the time. How about sometime the week of the 9th? March 9th? No? We're already talking
personally,
about
I'm good.
We're already talking about 2020. Let's see. How weird is that?
How about the 12th?
That's going to be where? It's going to be down south?
No, here.
It's going to be here?
Well, I assume.
Oh, no, you're right, because we're April now, so essentially this year, yes, yeah, okay.
The second
So,
Tuesday of the month, then.
Okay, the 12th is the Thursday?
Right.
That works?
Works for,
Okay.
12th would be a Tuesday, 12th, the second and the 12th and 19th, that would be booked. We can do it the 11th, we can do it the 13th.
Wednesday, Thursday?
Yeah.
Well, no, the 12th on 2020 is a Thursday.
yes.
Oh, okay.
yeah, the 12th is a Thursday.
Yeah, let's do 11/12, just in case.
Okay, so then you're
11,
going
12?
back to Wednesday, Thursday. You want to move that to Tuesday, Wednesday, or are you not available on March 10th?
Dave, what do you think?
Tuesday, Wednesday, I think is,
Sorry, I'm a little confused at what the,
Well, that's up here, though, Susan.
right, but I'm just thinking hotels. Christina, is
Oh.
it still, they try to advise doing Tuesday evening versus Wednesday evening? Okay.
So what's being proposed?
Well, I didn't know if you were going to go back to Wednesday, Thursday meetings because we had switched to Tuesday, Wednesday, where we were trying to switch to Tuesday, Wednesday based on Christina's recommendation of trying to get hotels. And it's a little easier on a Tuesday evening for some reason. But it's whatever you folks want to do. Mm-hmm.
Do we want to do 10/11 or 11/12 of March? Yeah, me too.
For me, I'd prefer 11th or 12th, but actually the week before that is better for me. So, but which would be any of the 3rd, 4th, or 5th, anytime. But I don't know if that works for the rest of the board.
I would prefer the week of the 10/11.
Right. So what about the 11th and 12th? Would that work?
Yeah, that'll work. Eleven, 12.
Okay, so Wednesday, March 11th and Thursday, March 12th.
Yep.
Correct?
Correct.
And here in Sacramento.
Correct.
Okay. Okay. Then,
Any comments from the public on that one? I know it kind of messes up the PCOC, kind of trying to align with PCOC. But I think it's better for the board, though, that we're able to meet a little earlier so we can potentially address any sort of legislative issues.
Yes.
Any other comments about anything else? Do I need a motion to adjourn, or can I just adjourn us? Adjourned. Thank you, everybody, for coming.